This here. I wonder if it's my op-eds in it from yesterday. All right, 63. Good morning, everybody. We're going to get going here. Start by the Pledge of Allegiance. Representative Brown, why don't you lead us this morning? Thank you, Representative. Mr. Clerk, when you are ready, could you call the roll, please?
Okay, Vice Chairman in Power,
Present.
Representative Guthrie, Clerk is here, Representative LaSalle,
Here.
Representative Ukella, Representative Kelly, Representative Allwood,
Here.
Representative Brown, Representative Cahill,
Here.
Representative Davis,
Here.
Representative Tetro,
Here.
Representative Trey Levin, Representative Gilman,
Here.
Representative Majori,
Here.
Representative Gallagher, Representative Hicks,
Here.
Representative Howland,
Here.
Representative Priest,
Here.
Representative Frack,
Here.
and Mr. Chairman.
Here. Okay. First up on our list today is Senate Bill 63, relative to the adoption of public health ordinances by municipalities. We'll open up the hearing on that. And I see Senator Gray here to introduce the bill.
Thank you, Mr. Chair. My name is James Gray. I am a senator from District 6, which starts up in Alton, Gilmanton, comes down Route 11 to Rochester. The bill in front of you, 63, has a story. It did not start off with the bill that you see in front of you. In fact, that bill, its origins was a House Bill 154. I needed a House bill to put the new voting machine language on, such that they taking out the language that is specific to the AccuVote machines, which you guys have already dealt with. So I put that language from House Bill 154 into Senate Bill 63 because I believe it had merit. I did not agree with the way it was done there and have suggested several changes as we've gone along. Originally, I put in the words that the condition that a health officer could regulate had to be unique to the town for them to work on, and there was pushback from the health officers and other people about that. So that the bill that you see that was passed by the Senate went through quite a several iterations of negotiations between the Senate and the Health Officers Association, all in trying to get us to where we were trying to get to, and that the health officers be limited to the original intent is that they would be able to deal with nuisances in their communities. Right now, the words are nuisances and other similar, okay? And that was, again, very painfully, I'm going to say, negotiated with the health officers to get the people on board so that they could deal with this. The concept of nuisances, as the attorneys tell me, is well defined in law. So adding additional language, as I've seen in an amendment that may be proposed later, is not necessary. It will not, by defining it as a nuisance and another similar, it will not let them put in mask mandates, in a pandemic. It will not be able to require people to get vaccinations. It will not allow them as Atkinson tried to do in the testimony provided by the representative during the Senate hearing, allow them to restrict tattooing only to licensed physicians. And if I go way back, it will not allow them to ban liquor or ban smoking or ban anything else, because those would not come under the nuisances. So again, I like the way that the bill is written right now. I can support the way the bill is written right now. And I hope that you will see the wisdom in what the Senate has done and pass the bill as it's presented to you.
Thank you for your testimony. Representative Brown, could you get the blue sheet and any pink cards that are up there for this? Questions, Representative Lascelles?
Yes, Senator, thank you for your testimony. The term nuisances or other similar threats to public health. Can you give me an example of that? That's kind of a broad brush there. Can you give me an example?
The example that I was using when I was talking with the representative was that if there was a noxious odor that was coming from either a company or a septic system or whatever, that would be again, the attorneys tell me it's well defined in law, okay, what a nuisance is and what a nuisance isn't. And that I think the amendment that Representative Harvey Bolyers has some examples in there, but I don't believe that that's necessary. I think it will hinder any enforcement of that in the future because you will have cited some and not others, and that right now, since it, again, I'm going to use the term well-defined in law, that you get everything that's in there right now, you don't get limited to anything else. But it will not include the things that we were most concerned about when we started this bill, and that is things that are of a regional or a state, where, again, mass mandate. You couldn't do that. You couldn't mandate vaccinations. You couldn't mandate certain things.
Follow up, Mr. Chairman?
Follow up.
So I guess the term nuisance, you would recognize it if you saw it, or you would recognize it if you smelled it, and it is defined in law, so it is purposefully rather nebulous.
I would say that was fair, that, again, to you and I, it may be nebulous. To an attorney, okay, who has all this case law to go back on, I don't believe it is nebulous, okay? So, the health officer needs to be educated in other things. They'll need to be educated in this. And if there is a question, that's why we have it in statute, so that you, the citizen, if you disagree with the decision they've made, can say that's not a nuisance, cite why you think it's not a nuisance, and go forward with it.
Thank you.
Representative Priest, yeah?
Thank you, Mr. Chairman. Sir, would you classify a pandemic like COVID as a nuisance?
No.
Representative Power?
Thank you, Mr. Chairman, and thank you for introducing the bill, Senator. My question is, could you tell me where in statute nuisances are defined?
I can't. Again, I depended upon the Senate's attorney to instruct me in this, and he told me it was well defined. Again, the statute isn't the only thing. It's decisions from the various courts that help to define the statute. So in addition to going and looking in the RSAs, you would also have to go into court decisions especially Supreme Court decisions that would define it.
Representative Majori.
Thank you, Mr. Chairman, and thank you, Senator, for taking my question. If I understand, if I heard correctly, it's kept intentionally nebulous to give the health officer some latitude.
Well, the words that are in there right now says, if you go back to the original statute, they had the ability to regulate nuisances. Then we add a little bit, and then we add a little bit, and that's what started to cause the confusion. So we're trying to get back to that original intent, the nuisances, and to get to a place where we could get agreement. That's why we said other similar things, okay? And the attorneys, again, told me it's nuisances is well defined. Okay, so to you and I, it may be a little nebulous. To an attorney, they tell me it's well-defined.
Follow up.
Thank you, Mr. Chairman. And that's kind of where I wanted to go, and maybe I'm just not understanding it. If it's similar threats and similar relates back to nuisance, and what we're trying to do is tighten the language, I'm not sure who's defining, who has the authority to define similar in the instance where they are out in the public. Is this similar to a nuisance or not? Because I agree that, actually, I haven't asked a question. Who defines what similar is?
I will refer back to the question that I answered from one of the previous reps, is that I can tell you easier what it's not. It's not the pandemic, items coming from the pandemic. It's not those kind of items, okay? And when I get to other items, it is worthy of a discussion.
Representative Brown.
Thank you, Mr. Chairman, and thank you for taking my question, Senator. I guess you mentioned earlier on in your testimony that the issue is with getting public health officials educated on what nuisance and how this is going to be interpreted. How is that going to happen, especially since we have questions already and we're adding things here that specify it a little bit more? But you're saying the nuisance and this type of thing, they need to have education. Who's going to do that for them?
Health and Human Services has a group that helps to do all that with the health officers. So,
Follow up.
So with the same follow-up, they already have this ability to get the training, and yet we seem to have problems interpreting the nuisance portion of this. How is this going to make it better as opposed to the training that's currently available?
the
Thank you.
language of the original bill, I don't know that I have it with me. I think I do. Or the statute as it is before it was amended by the bill. After it talked about nuisances, and then it says they can regulate other whatever, okay? And that's the part that caused the confusion and caused them to be able to think that they could do other things. And that's why we're trying to get back to that concept of nuisances so that they don't have authority to do other things. And like I say, I don't think I have that part of the statute right here.
It's just a struck
Oh,
out part.
if you look at the struck out part.
Yeah, I see that. Thank you.
Okay, relating to public health. So they could do anything that related to public health according to what they thought, and that's certainly not what I want them to be able to do.
Representative Davis?
Thank you, Mr. Chair. So RSA 147 is very well defined, and in fact grants to health officers broad authority and judgment to make calls to protect people from public health hazards, excuse me, and other kinds of nuisances. Why tinker with the well-established statute? Why not just come out with a bill that bans mask mandates if that's what you want?
It's not what I want. What I want is the health officers to stay within the box that the legislature has drawn. And health officers in Atkinson who decided that only a doctor can do a tattoo, you know, all the way back to 1972, when somebody said, well, gee, alcohol is a health risk, so I'm going to ban that in another state. You know, and we look at during COVID and all of the people who were the health officers were trying to regulate things that were not unique to their towns, that were not nuisances. And so they, in my opinion, they got out of the box. And certainly the genesis of this bill that comes from House Bill 154, the majority of the House members passed that and sent it on to us in the Senate. So there certainly was a concern that they were getting away from what the intent of the legislature was. So that's the reason. When someone, you know, takes words in the statute and manipulates them or interprets them in a way that was not intended in the beginning, what is the legislature to do? Either accept what they did or to file a bill that brings that language back into line. And so the representatives here in the general court said, well, we're going to bring them back in line. And that started with House Bill 154. When I took that bill and used it for something else, I put your language or the intent of your language into Senate Bill 63. So both the House and the Senate have already taken a position that something needs to change in that statute and that it is not being interpreted the way the legislature wants it.
Representative Diocella?
Thank you. Thank you for taking the question. Is your goal with this to essentially have some delineation between what is handled by DHHS and what is handled by the local municipality? That if it's handled by DHHS, then kind of the local municipality can help enforce those types of things, but they're not to go beyond what DHHS is saying for, you know, the bigger health emergencies across the state?
That question is getting far beyond what this bill does. I will give you my opinion. My opinion is that there needs to be a collaborative and a cooperative effort between Health and Human Services and the health officers. And when either side starts to stray too much from what the intent of the legislation is, that we need to look at the legislation and modify it. And that's exactly what has happened in this case.
Representative Gallagher?
So regarding the amendment, so I'm just wondering where it says such as currently, if that were changed to including but not limited to.
Representative Gallagher, Representative Gray is discussing his. He's not discussing the amendment.
I thought he had mentioned that was, I thought he was saying.
I
some,
certainly did
things in his
mention the
testimony.
amendment that
Right.
it's possible, and said that that as the language that I reviewed beforehand, I did not support because it was not part of the negotiations between the Senate's attorneys and the health officers when we reached the agreement on the language that you see in front of you.
My only point was I prefer to stick to what Senator Gray, I know we're going to have a representative speak to the amendment in a few minutes. Further questions? Representative Holland?
Thank you for taking my question. So this is kind of a follow-up on what Representative Yukela said. So rather than, because again, the statute is intentionally broad in terms of what nuisances are, and this makes it even broader with like similar threats, which is not defined. Instead of saying what the municipality can't regulate, why not have a bill that says what the state does regulate? And that way, when there's something like the pandemic and the municipality is unsure, it clearly delineates where the responsibility is for who is actually implementing the law, and then holds them responsible for if they are or they aren't.
My answer to that is I don't have a crystal ball, Representative. And if I knew, what to write down, I wouldn't have to be vague in any of these. Okay. So, again, the conversation with the attorneys goes back to the original legislation that we had talked about nuisances. They expanded that in years past for other things, okay? And we're trying to bring it back, towards that nuisances. And that's why, the definition of nuisances being well-defined in law and, not only through the RSAs, but through court decisions about what a nuisance is or isn't, gets us to where I need to be.
Representative Gilman?
Thank you, Mr. Chair, and thank you for taking my question. I was wondering if, since the wording is that health officers of a town may make regulations, do you feel that the ending of that says when approved by the selectmen is a safeguard?
Certainly, the selectmen are part of the process now, and if you look at the original Bill 154, it went further into that, and with town meetings and everything else. Certainly, I didn't think that was necessary and stripped that away, but there needs to be some check and balance on the health officers, and having that be the selectmen is fine with me.
Representative Majori?
Thank you, Mr. Chairman. Thank you, Senator, for taking another question. And this might be more confirmation. Since we don't have a hearing report on this, do I understand correctly? Did I hear correctly that the Health Officers Association supports 63 and the language that is in here now?
The last statement I remember is they do not any longer oppose it. I will not go to the part that says they support it, okay? The health officers, and since I didn't do the negotiations, and anything that I tell you is hearsay, because I didn't do that. I think I did get an email that says they didn't oppose it, but again, that's, I am almost 75, and, I don't remember every email that I got, so.
Further, Representative Davis?
Thank you, Mr. Chair, and thank you for taking another question. So has there been a public hearing on this bill?
There was several public hearings on this bill.
On this particular iteration of the bill?
Yeah, there was, if you look back in the docket, that we published the amendment or this exact version, probably not this exact version, okay?
That's exactly what I meant.
Well, again, you have rules on germaneness in this, and if you look at the bill that did have the public hearing and the information that was in there and talked about unique situations, et cetera, certainly, that, let's see, I had written such other regulation relating to public health for conditions unique to the town. Okay, those were changed, and it went back to the uniqueness. So I don't expect you guys to have a public hearing on every nuance that's changed, but the intent is clear, both in the bill that did get the public hearing, and what you see in front of you is that we want to get back to that definition of nuisances and things that are in the privy of the health officer to control because it's unique to that town or important to that town in the
Follow up, Mr. Chair.
Follow up.
Thank you, Mr. Chair. So just to be clear, and so I understand, I see in the docket that there was a public hearing on SB 63, which was an act enabling municipalities to adopt a tax credit for qualified private community property owners.
Correct.
And there was a public hearing on the bill that pertained to elections, but there's no public hearing on SB 63 as it comes before us today.
If you will look into there, you will see the amendment, and the public hearing was held on the amendment. I'm not trying to educate you on procedure, but both in the House and the Senate, until the body acts, the title of the bill does not change. And that is only accomplished when an amendment is adopted by the body. Okay? So the title didn't change until that amendment was accepted. And that's why when we publish the amendment by the amendment number, and that the public hearing is, and we make the amendment at least available, if not, but it was there at the public hearing, and you can see the public hearing report if you go in and look, and clearly Representative Boyer, Harvey Boyer was there testifying against it. They are testifying to it. The health officers were there. Again, I'm not trying to educate you on the policy, but this is the same thing that happens all the time in these House committees.
Further questions? Excuse me. I have one, Senator. So talking about nuisances, we see that in RSA 147, it's actually very well defined. You stated that the attorneys believe that nuisances are well defined, and I probably agree with that. Looking at the SB 63, wouldn't it, rather than adding, striking out that language and adding or other similar threats to public health, why not just strike out that one sentence? Wouldn't that get us to where we want to be, where it's just nuisances? Because I agree that when you start trying to define individual things, it becomes watered down and pretty much useless.
In trying to get to an agreement, to consensus with the health officers, okay, they wanted words in there that talked about other similar things. So again, is the bill perfect the way it is? If you ask me, no, but it is perfect enough that I can support it. And as I said before, I believe that the health officers have said that they no longer oppose it. Okay.
Very good.
So we're trying to get to that sweet spot where nobody is completely happy, but everybody says, yeah, we've done the right thing.
Gotcha. Representative Cahill?
Thank you, Mr. Chair. Thank you, Senator, for taking my question. Don't you think that we should be looking for the approval of the people and not necessarily the health officers? I mean, striking the language as suggested by our chair, I think would be the right thing to do. And the people is who we should be looking out for, not the health officers.
Again, Representative, that's why you're a representative, is you have an opinion. Okay. Who is the right people to guide me? Who is supposed to have the knowledge of how different compounds or different odors, different situations are going to affect me? That's the health officer. And through statutes, we have invested both in Health and Human Services and the health officers in the towns certain responsibilities for providing us the correct information, detailed information about that. And so I am going back the way the statute was in the original form, is that, yes, these health officers have special knowledge, and that's why we consulted the health officers.
Follow up.
Sir, to your knowledge, do you know if every single town or municipality has a health officer?
I believe that the state, when they don't have a health officer, performs those duties.
Okay. Representative Power.
Thank you, Mr. Chairman, and thank you, Senator, for taking a follow-up question. Is it true that some nuisances require immediate attention and therefore it would not be impractical to, for example, wait for an annual meeting to get the approval of the legislative body if it's a town?
I believe that is correct.
Further questions? Seeing none, thank you very much, Senator, for your testimony. Next up, we have Representative Harvey Bolio.
Thank you very much. How's everybody doing? For the record, my name's Representative Juliet Harvey Bullia. I represent Belknap District 3, Tilton and Samberton, and I have passed out a packet for you. And you also have an amendment, and that would be amendment number,
1505H.
yes. Thank you. Senator Gray just did a very good job of basically introducing everything. And I appreciate all the work that has been done on the other side of the wall with regards to this issue. Members of the House have been working on this particular section of the RSA since 2020. And I've included in the packet a recent bill history. It probably goes back farther than that. But as far as what I've done on this particular section is here under recent bill history. When this bill, under House Bill 1272, and I have included the language here, a very similar version of it passed on the consent calendar by this committee. And it went on to the Senate. But so what prompted this bill in the first place was obviously, I think everybody knows at this point, the mask mandates. But I don't want to say that this bill is about mask mandates. It is not limited to that by any means whatsoever. So I appreciate your indulgence in thinking about it as a whole, as has already sort of been talked about by Senator Gray. But personally, I went to my select board and in my town, and my selectman said that he would prefer if he could place everybody under a vaccine mandate for the entire town. At this time, it was the height of the COVID pandemic. And I thought, well, sure as heck, I do not want to wake up one day and have a vaccine mandate addressed to me and myself, my whole town. Now, I just want to sort of address the fact, and I have put in, if you look on page 3, I've put in the entire Title 10 Public Health chapter as it is seen. If you look in the RSAs, it's got the title and everything. I think it's very telling that it's about nuisances, toilets, drains, expectoration, rubbish, and waste. And some representatives have brought up, well, obviously the legislation pertains very broadly, and that has been how it has been interpreted by some, is extremely broadly. It says, and the actionable clause here is, and such other regulations relating to public health. That's what the discussion is about. As in their judgment, the health and safety of people require. So some have brought up, well, that's a carte blanche. But I would argue for two reasons it is not. For one, there is no requirement for any public hearings whatsoever. If you read, it shall take effect when approved by the selectmen in a possibly as little as just a public meeting. So it doesn't even necessarily have to be listed on the agenda. They simply have to pass it at a public meeting and post it. To me, that begs the idea that this is really what possibly they meant to write is they may make regulations for the prevention and removal of nuisances and other similar things to nuisances as Senate Bill 63 now stands. They meant it as obviously to be limited to such local things as nuisances, and we'll get into the definition in a little bit. So for one, that is why we have that. You got, it would have been. So when selectmen make regulations and ordinances, usually it requires public hearings. There's a process. When you have a zoning amendment, it requires 2 public hearings. It's extensive what has to happen in order for a zoning amendment to pass. The 2 public hearings, it's in the statute. So in my opinion, that and the title of this section does not belie any sort of carte blanche to make any sort of law that they think is vaguely relates to public health or any sort of thing that could be construed as public health. Okay. So I have put in, by the history of the bill, which Senator has already introduced. And at the bottom of page 1, it's got the role of the health officer. This is just taken off the health officer website for our state. They have broad authority to investigate public and sanitary concerns. Health officers shall inquire into all nuisances and other causes of danger. These may include, and they list, the typical things: garbage, pests, unsanitary conditions, septic failures, rodents, and more. There are no training or qualification requirements beyond providing your criminal records history. And you get a 3-hour training course. And I'm not saying there are some health officers who have degrees in public health, but by and large, for most towns, this pertains to the health officer, which also maybe, for instance, in our town, does other things, is also a selectman. And they're possibly wearing multiple hats. They have taken the 3-hour training. And that is all that they have. Otherwise, they're an employee. On page 2, I've listed a whole bunch of items because in the past I've received questions about, well, what about, asbestos, and what about bed bugs? And so this page on page 2 is just a list of all the different RSAs covering all sorts of other things that health officers have to deal with. And I think the reason why health officers generally don't show up to these types of hearings, I'm wondering if, they don't want extra duties. Because if you look at this is, their plates are full. And this is a partial list. It goes on to page 3. This is by no means the end of the list. There's quite a bit in there, and I invite anyone to go onto the website. There's little pages for each subject matter. One of them is communicable and infectious diseases, which at the end of the packet, after, I guess it would be page 9, but it's not listed, there's a section called communicable and infectious diseases. And just, the reason why I bring this up is because I want everyone to see that it's in no way has DHHS, in any of the guidance documents that I've read through, ever advocate mask mandates, health mandates, keeping lists of your guests' tattoo ordinances against tattoo parlors, or that would inhibit requiring of extra licensing for businesses. So under this communicable diseases guidance from DHHS, it is the role of the health officer is mainly a supportive role of reporting cases of disease, dispensing of educational materials, posting signs regarding swimming or contaminated beaches. So I can't find anything in here about passing ordinances, or other such things. So it is quite consistent with all the documents on their website to limit, as Senator Gray said, this language is very important to keep health officers within their box. I think they'll actually appreciate this, and having it defined and having a more tightly written language for them to adhere to. So in your packet as well, I have a couple of examples. On page 4, it's an ordinance by the town of Hanover. I just wanted to give you some examples of mask mandates. This one, number 39, is the mask mandate for Hanover. It cites New Hampshire RSA 147:1 under the authority. There were probably 6 towns that had mask ordinances in cities, and they did use this particular RSA. This mask mandate that Hanover wrote applies to any outdoor area where businesses are doing business. It mandates that businesses must post the requirement for a mask, and it only pertains, if you look at number 7, to certain zones. So I assume they think that people are familiar with their zoning. Under number 8, it pertains to children under the age of 2, or up age 2 or older. So this is, I guess, to give you an idea of how complex some of these laws are. It's not simply we pass a mask mandate, it's going to expire at a certain time, and it's very temporary. We got Lebanon has their own. They also cite RSA 47:17. It applies to any business, governmental or nonprofit owned business, and also public transportation. Okay. And they have it apply to children 3 years of age and up. That also has an effective date, but no expiration date. So at the bottom of page 6, I get into a few of the business-related ordinances that have passed things that make it difficult for businesses to establish themselves in town. Otherwise, legal businesses that have their own New Hampshire licensing requirements. We have tattoo parlors and massage parlors seem to be the main issues here. So on page 7, you have an example of the Exeter health regulations and other establishing a license, a separate license, if they want to establish a massage parlor, for lack of a better therapy. Under, let's see, the application section, under license 1203.3, each license shall expire within 1 year. No license shall be issued to the applicant if the individual has been convicted of a felony. It's quite specific, as you can see. And it incurs an additional fee of $50. Atkinson has a very similar one, and it also cites RSA 147:1. Under, at the top of page 8, it says that the purpose of the ordinance is to protect the safety, health, and welfare. So it seems to be, again, where they've taken the clause any other regulation and had quite a bit of liberty with it, I would say. So just to briefly touch on, and I'm almost done, I'm wrapping it up. Okay, one more example is the tattoo parlor, where on page 8, under Article 3, this is where it says that only a qualified physician shall mark the body of any other person by means of a tattoo. That some would construe, I'm not going to assign motive, but some would construe that as an effort to keep out undesirable businesses from town. And then you have the Albany still has on their books and on their website as of today this sort of ordinance that prohibits the possession of alcohol on public streets. It doesn't say whether it's an open bottle or not. I assume they mean open bottle, but it doesn't say that. So about the whole subject of nuisance definition. So I have not been able to find a definition of nuisance in our statutes that pertains to this public health. There are some definitions that pertain to like things to do with controlled drugs and other sections, firefighting, I think, but not that I have seen yet. But the New Hampshire Public Health Nuisance Task Force in 2010 did have a task force, and a 27-page document that has, and I'll send everybody the link, for the sole purpose of investigating this particular portion of law. So I hope you all read it, but so it says that they're from their document that they put out, they express the need to better understand and define RSA 147, nuisances, toilets, drains, etc. To achieve this goal, a public health nuisance task force was formed, comprised of a diverse group of professionals. And it's a very good document. There's a lot in there. One of the things that's not in there, though, is sort of a suggestion, any kind of suggestion in any way that health officers stray from such ordinary things as that is defined. And they do define what a public health nuisance is in this document. I have put that definition at the bottom of page 8. Nuisance defined, this is just copy and pasted from the document. And I'm not going to read it to you because it is exactly what you would think. It is, it interferes with the use and enjoyment of property and is related to land use, basically. It is not about an individual's behavior, etc. So that is why, if the chair is okay and with me discussing my amendment, the reason for my amendment, is that a permissible?
You may,
And that's-
if you could kind of make it a little quick.
Yes, I'll
Because
make it
we
very
are
quick.
already way behind.
Oh, okay, sorry. So I created this amendment based off of the list from the New Hampshire Health Officers Association, which is on page 3, which they suggested that they needed these sort of things to act on in an emergency: groundwater contamination, septic breach, hazardous waste release, and flooding scenarios. This is directly from their suggestion. And I have had requests to firm up the language because we are not lawyers, I suppose. And a lot of individuals read this. For instance, well, I mean, this applies to towns, and the legislative body of the towns are their voters. So it seems to be that we want something that is specific enough for the layperson to understand what other similar threats might be. So I have put in other similar threats, such as groundwater contamination, as far as PFAS, septic breaches, etc. And that is to give the public an idea of what that is supposed to mean, and also the health officers, so that they might understand that as well. And I apologize if I went too long. Thank you very much. If you have any questions.
Thank you for your testimony. Comments, questions? Representative Parr?
Thank you, Mr. Chairman, and thank you for taking my question. So I understand that as an example of an overreach, an application of RSA 147 would be what we saw during the pandemic with regards to COVID. Would masks or vaccines either prevent or remove COVID, which was construed to be a nuisance?
Thank you very much, Representative. Your question is, would masks? No, I don't believe so. I haven't found any information to the contrary, that masks were not. In fact, I believe I had testimony before this same committee last year where I studied the different mask mandate, different towns that had enacted mask mandates and their rate of COVID. And by comparison, they were no different than their immediately surrounding towns. Thank you.
Representative Priest?
Thank you, Mr. Chairman, and thank you for taking my question. Do you think that an outbreak of communicable diseases like measles or hepatitis would be a nuisance under your amendment?
Thank you for your question, Representative. No, not nuisance. So nuisance, even if it's not defined in RSAs, is actually defined in the dictionary. So I assume, and I'm not an expert in this sort of what the lawyers would say in a court case, but if it is not defined, nuisance, the common definition, I would assume still is defined, is that particular definition would still apply. So COVID is not a nuisance, but any other sort of thing, that is the operative term here. Thank you. I hope that answers your question.
Further comments or questions? I have one for you. Over here, Representative.
Oh, sorry.
The original language that was in HB 154,
Mhm.
and just a very quick answer, do you think that is better than either of these, the two amendments that are sitting before us?
Thank you for your question, Chair. I think the priority is to limit. I think the priority is either Senate Bill 63 or, with all due respect, my amendment. I think that is the priority here, is to define this properly. I think that is the most important thing at this time. I think it's my original House Bill 154, which is in here. I put it here. It doesn't limit anything.
I just wanted to know if you
So,
thought which
sorry.
one was better in your opinion, that's all.
Yes. Okay. Thank you.
Representative Yokella?
Thank you. It seems like you've done a lot of research on this. Are you familiar with any power of like the legislative body or DHHS to identify like the overreach, let's say in the tattoo parlor, or let's say banning alcohol on all streets, or the possession of alcohol on all streets? When the legislative body or the DHHS identifies that as being outside of the scope of what is reasonable, do they have you found any power granted to those people to be able to affect that change, so that, you know, the legislative body could, I don't know, rescind the health ordinance, or the DHHS has the power to say this is not appropriate, this is, you know, have you seen anything like that, or is it just up to the health officer and maybe the selectman?
That's a great question, Representative Yokella. I have not seen anything. As far as a clawback, I assume there's a possibility that there's a rule somewhere, but I haven't heard of any instances of that happening. Thank you.
Representative Gallagher?
So about the amendment, if the such as were changed to say including but not limited to instead, what would that change your thinking on the amendment at all?
Thank you very much, Representative Gallagher, for that question. That's an interesting point that you raise, and I don't think it's personally. I don't think it's necessary, because or other similar threats. That doesn't limit it. It's not saying. It's giving examples. So, or other similar threats is really the operative. I see it as the operative phrase here. And then my addition of just such as is just, it's sort of like a helping phrase, for lack of a better term. I don't think it's necessary, but I think the more qualifiers you put on there also, I'm not sure, to be honest.
Seeing no more questions, thank you for your testimony. I have one more pink card, but
Thank you very much.
is she coming back in? I don't see her. Melissa Blasik? No, she's not here, Richard. Representative Brown? All right. Not seeing her, we're going to go ahead and close the hearing on SB 63 because we are way behind. I apologize to those in the back of the room here for other bills. The chairman once again has underestimated the timing on the very first bill. With that, we will go ahead and open up the Senate hearing on SB 531. Senator Gray, I see you are here to introduce this one.
Thank you. For the record, my name is James Gray. I represent Senate District 6, which starts up in Alton, Gilmanton, comes down Route 11 to Rochester. This one, hopefully we can get you some of your time back a little bit. This bill has to do with local control, and that the state does not need to be involved in background checks of your health officers. You know, certainly they do have an oversight of the health officers as part of the responsibility, but certainly the local governments are well within their capability of choosing their health officers and investigating them. We don't get involved in a lot of the other employees that the towns hire, so we don't need to be involved in this one.
Representative Brown, could you grab me the blue sheet on this bill, please? SB 531. Questions for Representative Gray, Senator Gray, Representative Yokella.
Thank you. Thank you for your brief introduction. However, reading the bill, it seems like in line 2 and 3, the state is still requiring that municipalities shall request and obtain the criminal history information. It seems like the change of this law is just that it doesn't need to be submitted to DHHS anymore. Is that your
Pretty much.
Okay, thank you.
Representative Priest?
Thank you, Mr. Chairman. And thank you, Senator, for being here. Has there been a problem in the local governments, municipalities, towns, where the health officers was a security risk? And this is the reason why we're having this law?
Again, I believe that the statute out there is for them to do this is existing, so that if I keep on doing it, then I don't have a problem. So I can't really answer your question, but for right now, there's no reason why that needs to be done at the state level. It can be done at the local level.
Follow up, Representative Priest?
Yes, thank you. As a follow-up, was there a problem with the localities not doing this, not requesting this as a part of their hiring process?
As best I know, I don't have all of the background on this, but when the department came and requested it of me, it was an ongoing process to do these background checks, and having it done at the local level should save time and effort, because when they're considering people, they won't submit people who can't pass a background check.
Representative Park?
Thank you, Mr. Chairman, and thank you, Senator, for taking my question. So just to be clear, is it correct in my understanding that the requirement for the municipality to obtain and then submit the criminal history record to DHHS, was that for the purpose of DHHS reviewing that?
They can speak to that when they come up to testify, but that's that was part of the approval process, is that there be a background check done. Yes.
Further questions? I have two quick ones for you, Senator.
Yes, sir.
On the language itself, there are two phrases that I'd like you to give me a little input on. One is on line 7 when it talks about shall employ its discretion. What does that mean? Let me get to the bill itself. I probably would rather the Health and Human Services contact you, testify on that. We can do that. Okay. That's fine. Most of the input that I had in here is that the original suggestion, when it came to me, did not talk about the Health and Human Services oversight. And they still have an oversight role in this, even though they're not doing the selecting or doing the background check. And since you brought up that word, that was the other question I had for you on line 9. What does subject to oversight mean? Is that something better that they're going to answer, or?
I would think that the original bill didn't have that, but when they testified in the Senate, they were also espousing that. Again, they do have a role in the health officer's activities. And so I wanted this bill as modified to recognize that role, and I believe that they will talk to that.
I'll hold those questions for them then. Thank you. Further questions for Senator Gray? Seeing none, thank you for your testimony.
And I apologize, but I do have another appointment, so I'd like to stay.
See ya. Okay, I only have, if there's any other pink cards, anybody wants to speak on this, please make sure you get them up there. I have next Sophia Johnson from DHHS.
Good morning, Chairman Turcott and members of the Municipal and County Government Committee. My name is Sophia Johnson, and I'm the Program Manager for the Health Officer Liaison Program at the Department of Health and Human Services, Division of Public Health Services. Thank you for the opportunity to provide testimony in support of Senate Bill 531, an act relative to the background check of municipal health officers. Senate Bill 531 is department-requested legislation. The legislation proposes to amend RSA 128, Section 9 to no longer require municipalities to send a health officer candidate's background check to the department as a prerequisite to any nomination. The department has a legislative mandate to appoint and assist town health officers via RSA 128. While town health officers are department appointed, they're ultimately town employees nominated by a board of selectmen and served subject to local human resource practices. As town health officers are municipal employees, we believe that they should be subject to established local hiring practices prior to confirmation by the department. The legislation, if enacted, would provide local municipalities the authority to determine what convictions on a candidate's background check would be considered disqualifying, consistent with its own established hiring practices. Additionally, the proposed legislation would remove the department's responsibility to review and store candidates' background checks, which are sensitive documents. This would eliminate any privacy concerns related to background checks. The legislation does retain the department's ability for oversight in the appointment or termination of health officers, if warranted. In closing, the department believes that Senate Bill 531 restores local authority in selecting town health officer nominees, reduces privacy concerns, and decreases administrative burden. Thank you for your time, and I'm available for any questions.
Representative McDonald, Mr. Clerk.
Thank you, Mr. Chairman, and thank you for taking my question. Where can I find what the disqualifying things would be for not being a health officer? What would disqualify me from being a health officer?
What would be considered disqualifying? Is that
Yes.
what I'm
Are
interpreting?
they in your rules, or where are they?
I know that our rules were amended this year. We actually added rules to RSA 128, and to be honest, I would have to review those rules to determine what is defined as being able to be removed.
May I just do a follow-up?
Absolutely.
What are the current rules that you're aware of? Are there any?
I am not aware of any at this point.
Okay, thank you.
Thank you.
Representative Yokella.
Thank you. Kind of going back to your statement about oversight and specifically around termination, what does oversight mean? Like, for example, the ones that have been proffered here today about regulating tattoo parlors, or banning alcohol, possession of alcohol in a does the DHHS have any power to say, hey, you've done something inappropriate and fix either, are you guys actively kind of monitoring them and saying like, hey, this is good or this is approved? If you found something that was inappropriate, do you have the power to say that this should not be a health ordinance, or fire the person entirely? What is the scope of the oversight?
Sure, that's a great question. So we provide health officers that appointment, right? Like you are confirmed by the department to fulfill the requirements of health officer law, but you are a town employee. So health officers act in a way that their towns have oversight over local laws, passing local laws. We know that some towns regulate tattoo parlors and some towns don't, but that's a municipal authority that we don't want to overstep that authority. Certainly in situations where there's potential groundwater contamination, then DES's rules come into play, and DES would have additional oversight over those particular cases. So in many situations that health officers respond to, they're working alongside another department. So there is that oversight as they respond. But primarily, if your question is passing local ordinances, that's, again, subject to the town's requirements, the town's processes, if I'm answering your question correctly. In my tenure, I am not aware of any times that we have had to remove a health officer. Towns will come to us if there's questionable conduct by a health officer, and we can certainly review that history or that activity that the health officer has engaged in. But there's never been a situation rise to the level where the department has removed someone from the position.
Follow up.
Okay, so your statement is that you've never seen someone actually be removed, but also implied, I guess I want to make explicit in your testimony, is that since it is confirmed by DHHS, there is a potential for DHHS to remove that confirmation and say you are no longer allowed to be the health officer.
Yes, we certainly have that authority within the law as it is now. Thank you.
Representative Elwood.
Thank you, Madam Vice Chair, for taking my question, and welcome this morning.
Thank you.
Is it true that towns share health officers? Smaller towns share?
So in certain situations for small towns, it is very hard to find someone to fulfill this role. So one health officer may serve in multiple towns, but they need to be appointed in each of those towns. So for example, if the health officer in Chichester is asked by a town of Epping or to serve Epsom, then that health officer can certainly serve in both towns. The department would just need to make that confirmation for them so they can serve concurrently.
Thank you.
Yes.
Representative Power.
Thank you, Mr. Chairman, and thank you for taking my question. So is it true that in the roles and responsibilities and duties of a health officer, would it be true that they're dual-hatted and that they function as on behalf of the state departments as well as local municipalities?
So they are municipal employees who serve at our request, and very often, they conduct school inspections on behalf of the Department of Education. They do foster care licensing inspections for the Department of Health and Human Services. So they act on behalf of the departments in certain situations, but they are municipal employees. I hope that answers your question.
Further questions? Representative Brown.
Thank you, Mr. Chairman, and thank you for taking my question. So what's the position on the towns? Have they given you any feedback in regard to them wanting to take on this responsibility?
So I have received concerns about privacy, that why do I need to send this to you? To be very honest, when we've already done this and this background check result is satisfying by our standards, why then do you need to have that additional review process? That's what I've heard.
Follow up, Mr. Chairman. So what I really meant is that have the towns requested that responsibility go back to them in all cases? The overall responsibility for the review process of this, as opposed to them having the responsibility and then the state wanting to take it and just say, we would like this responsibility ourselves, period.
So I haven't gotten that request directly. I've gotten concerns about why do you need to see this? That's what I've.
Thank you.
Representative Yokella?
Thank you. Thank you for taking another question. So going back to the fact that you have to confirm, essentially authorize, even though the person got hired by the local municipality, you have to confirm at DHHS that they are allowed to provide this role.
Yes.
What, if not the background check, are you using to decide whether or not someone is appropriate for that role or not?
So that's determined at the local level. The town determines what candidate they would like to serve in that role. They perform the background check, and then they submit that candidate to us. There is no other requirements that we look for in order to say that's an appropriate candidate or not. It is the town's responsibility.
Go ahead. Follow up.
So I guess with your response, why even have your guys' perfunctory coronation, if you will, if you guys are not ever denying anyone for any reason? I guess why even have that legislative or that regulatory step?
Yeah, it's a great question. So in a lot of cases, always, it's important for us to know at the local level who is the health officer. So in cases of emergency, cases of concerns that come to our level, we want to know who to be able to contact at that local level. That information, that emergency contact is very important for us, especially in situations of emerging concerns or emergency situations. And again, health officers do serve for the department in a number of functions, like these types of inspections of schools and daycares and foster care licensing. So it's important to have an appointed person to perform that role.
Representative Cahill.
Thank you, Mr. Chair. Thank you for taking my question. So in your testimony, you're talking about these other things that you're using the health officers for that are not the purview of the town. Those are separate agencies. Do you think do the health officers have access to other private information, other information that they wouldn't have through the town, through you guys?
We don't share private health information, protected health protected health information or identifiable information, except in situations of communicable disease where the Bureau of Infectious Disease Control, if they're investigating a certain situation in a town, they have a privacy agreement with the health officer. The health officer has taken all the privacy training, HIPAA training, and that's outlined in RSA 141C. There is that protection, an agreement outlined that health officers need to have in order to receive protected health information.
Further questions? I have one or two. Line 7 that I asked Senator Gray about employ its discretion.
Yes.
Could you give me a little information? What exactly does that mean?
So the sentence states each municipality shall employ its discretion when reviewing background checks. So every town has its established hiring practices, and they may have guidance on what type of conviction would be disqualifying and what type of conviction would not be disqualifying. So the municipality has its ability to utilize its own hiring practices and interpretation of qualifying or disqualifying convictions to apply to this nomination.
And second question, maybe simplifying the questions that Representative Yokella asked about oversight. Is it my understanding that even though the town's going through the search process, would you, the DHHS, still have the ability to basically veto a health officer's appointment to that town?
Yes, we can.
Thank you. Further questions? Seeing none, thank you for your testimony.
Thank you very much.
And I believe that's all the pink cards we have on that. Anybody else wanting to speak? I see none. We'll close the hearing on SB 531. All right, we'll go ahead and open up the hearing now on SB 447, establishing a committee to study the inclusion of transportation expenses in default budgets. Senator Chandley, you are up.
Thank you very much, and good morning, Mr. Chair, members of the committee. My name is Shannon Chandley, and I have the honor of serving the people of District 11 in the State Senate. I come before you today to introduce SB 447 relative to funding school transportation services under the default budget. The bill establishes a study committee, something I know that we are sometimes reluctant to do because there are so many, but I would submit that this is an efficient and nimble way to get some answers about a very complex subject. The original bill, what I originally intended was to try to address the issue of default budgets related to transportation in a single bill. But what became clear immediately is that the issue is complex and may require the input of more stakeholders to understand the best solution. It was a request of one of the SAUs in my district that has had to rely on default budgets. While the SAU is required to transport some students in certain circumstances, transportation budgets are not included in the default budgets, despite the fact that they are often contracts. This has become a problem in some communities, and this bill here does not propose a solution, but in fact proposes a way to get to a solution. I ask that you look favorably upon the bill, and I am happy to take any questions.
Representative Cahill.
Thank you, Mr. Chair. Thank you, Senator, for taking my question. Outside the solution, we probably do need to find a solution. But here on line 5, it says it would be 1 member of the Senate, and on line 6, 3 members of the House of Representatives. Do you think that since the Senate is requesting this, that maybe there should be multiple members of the Senate, equal share of workload?
I don't think that would be the best solution. I think that since there are 400 members of the House, there's a lot of talent on which to draw, and there are 24 senators. So I really do believe that the 3 representatives would serve well. And of course, the 4 members of the subcommittee could call upon any stakeholders who might be able to provide good information for the committee.
Representative Yokella.
Thank you for taking the question. So being very familiar with the default budget law, it seems to me that if the transportation was required by law, let's say if you're far away from the school or whatever the case may be, or special ed or whatever, those things required by law would be able to be included in the default budget. And if the contract that you stated was put before the voters instead of just signed by the school board, then it would be able to be part of the default budget. So I guess my question is, what situations other than things that are required by law, and then the other transportation is just not a one-time expense, so it's recurring, so it would be flat every single year. So I guess where is that need not being met, I guess, in all those 3 different cases?
So from my understanding from the SAU is that they were not able to include the transportation budget in their calculation. Now, I also did speak to the Municipal Association, and they were more than happy to take part in this discussion because they believe that we need maybe perhaps greater education and understanding around default budgets.
Further questions? Seeing none, thank you very much for your testimony. Next up, we have...
Thank you.
Yes, thank you. Barrett Christina?
Thank you, Chairman Turcott. Good morning, members of the committee. My name is Barrett Christina. I am the Executive Director of the New Hampshire School Boards Association, speaking in favor of this bill. As Senator Chanley stated, the bill doesn't really provide a solution to some of the challenges that school districts are facing with rising transportation costs, but hopefully the study committee or the study commission can help a statewide discussion on what school districts might be able to do to either include that in the default budget or to at least address some of the rising costs that we've seen relative to school district transportation. I have a handout here, not a handout, but I have a short PDF of just to identify the rising costs that school districts are facing with transportation. The Litchfield School District, their FY24 cost was $371 per day per bus. Their FY25 cost is going to be $445 per day per bus. Dairy, $421 per day per bus. For FY24, for FY25, $459 per day per bus. So we're seeing at least a $50 per day per bus increase for transportation costs. I presume there are many reasons for that. Having a hard time finding bus drivers, so those districts are having to increase their pay, or not sorry, those districts, but the bus companies are having to increase pay or have longevity bonuses or sign-on bonuses. I presume that the price of diesel is also driving up some of those costs as well too. So anything anytime we can get a group of stakeholders across the table to help look at some of these issues that are impacting local school district budgets, the School Boards Association is in favor of. So we support the bill and would be happy to provide whatever expertise or knowledge or background or information we could if indeed there is a study committee or a study commission that moves forward. And that concludes my testimony. I'm happy to answer any questions.
Representative Yokella.
Thank you. Thank you for taking the question. Kind of alluding back to my prior question, and since it seems like you have some stats, do those districts that you were just referencing have a contract with that bus company that could have foreseen those increases, and if that municipality had put that contract on the ballot, be included in the default budget, would that have solved the problem that you're raising here?
Sure. Thank you for the question, Representative. That's a good question. Most of the contracts that school districts are signing with transportation companies are 3 to 5 year contracts. And one of the challenges is that I believe there's only about 2 companies in the state that are providing transportation services to school districts that don't own their own buses. So it's not a very competitive market for school districts. In the superintendents and school board members that I've spoken to that have negotiated transportation contracts over the last couple of years have been over a barrel, to be quite honest with you, because the transportation company is saying, this is the cost. This is what we're charging you. And if you don't want to sign our contract, the school district is up a creek. And to your question about whether or not they could put the transportation contract on as a separate warrant article, the risk with that would be there are certain transportation obligations that school districts have to follow. Special education, as you mentioned, Representative, and RSA 189:6 states that the local school district shall furnish transportation to pupils in kindergarten through grade 8 who live more than 2 miles from the school. So if the transportation contract were to go on the warrant as a separate warrant article and was defeated, I don't know how that's rectified, because you're not allowed to appropriate money under that contract then if the voters said no, but you still have statewide obligations to transport kids for special education and under this statute. So you could bifurcate that contract somehow, but you'd have to go back and renegotiate it with the transportation company.
Nope. Yes. Go. Representative Tatro.
Thank you, Mr. Chair, and thanks for taking our ongoing questions on this item. The default budget is defined quite explicitly in the RSAs on what can go in and what can't. But So aren't we kind of, it's already in the budget, so if they get the default budget, the money that was allocated last year for the school buses is already in there. Are you saying that the voters, well, I suppose you could take that line out at your public meetings, but the other RSA makes up for it as far as being required within, beyond 2 miles and special circumstances. But I guess my question is this already taken care of?
Thank you for the question, Representative. I guess I would harken back to Senator Chanley's testimony where she said in speaking with one of the school districts in her district, in her Senate district, that they were either informed or told or calculated the default budget absent some of the increased costs that these new transportation contracts are costing. I don't know specifically what district Senator Chanley's referring to, but the fact that the bill was put in place at the request of an SAU or a school district because there were concerns relative to transportation costs within the default budget, I would say that that's kind of why we're here and why the bill was introduced and why we're having this conversation.
Representative LaSalle.
Thank you for taking my question. Could you tell me, in the current default budget situation, what transportation costs are allowed in that default budget?
So thank you for the question, Representative. Well, so as I presume most, if not all, of the members of the committee are aware of, the default budget includes in part of its definition contracts and other obligations previously incurred or mandated by law. So special education transportation would be mandated by law. The transportation of pupils in grades kindergarten through grade 8 who live more than 2 miles from school would be required by law. A school district, however, may provide transportation to high school students, which is not required by law, but yet would be calculated into a contract with a transportation company. Likewise, the school district may also provide transportation to pupils in grades kindergarten through grade 8 who live less than 2 miles from school. So, I mean, I don't know if could a business manager or a superintendent of a school district pinpoint where each child lives and then ascertain or calculate a cost per pupil, and then that might be taken out of the default budget because you'd only be able to put in the default budget the costs that are required by law, the special education and for all the children that are within the parameters of RSA 189:6.
Go ahead.
Follow up. It's my understanding, although there is this 2-mile rule, that most school districts say, if you want to ride the bus, we're going to provide you a ride to the school. Whether you live in our district, we had one student who lived directly across the street from the school. But the parent requested that the child be picked up because they didn't want the child walking across the road.
Right.
So in that case, where the school district is providing transportation above and beyond what is mandated, is that included in the current default budget negotiations or calculation?
Yes, thank you for the question, Representative. I'm not trying to be evasive, but I mean, I can't speak to 161 school districts and how they're calculating their default budget. Well, less than that, but for the SB2 towns, let's say there's 100 school districts that are SB2. I mean, I think many school districts calculate them a little bit differently, to be quite honest with you, depending on the advice that they get from perhaps their own local attorney. I will also tell you that I'm aware of some school districts that will provide high school transportation for high school students, but the parents also have to pay some amount. It's probably not the full amount that covers it, but I'm aware of some school districts that will say if you're a high school, whether you live a mile from the school or 10 miles from the school, the parents have to pay $100 a year or something along those lines to help defray some of those costs.
Okay. Thank you.
Thank you.
Representative Davis?
Thank you, Mr. Chair, and thank you for taking my question. It's just a simple question, I think. Is the origin of this bill the problem of one SAU, or is this a statewide issue?
Thank you for the question, Representative. I will tell you that, and I know this doesn't get to the default budget question, I will tell you that rising transportation costs are a statewide issue. The default budget issue, I can't specifically speak to.
Follow up.
So the factual answer to my question is that you don't know. Is that correct?
Correct. Yes.
Thank
That's
you.
fair enough.
Representative Priest?
Thank you, Mr. Chairman, and thank you for being here and for all that you do for the school districts. Again, my understanding is that this bill would look into all those cases in the towns and municipalities that have transportation costs in their budgets and studied this situation because of the rapidly changing fuel cost and other costs that are pertaining to transportation that they cannot foresee. Is that correct?
Thank you very much for the question, Representative. Yes, to some degree, that is why NHSBA is supporting the bill. Aside from looking at the default budget, I believe I led some of my testimony with saying I hope that perhaps that conversation can also, may not be the direct purpose of that study commission, but hopefully that would come out in the conversation of what are some of the other drivers and what are some of the other challenges school districts are facing relative to transportation.
Further questions? Seeing none, I have one.
Yep.
Kind of a 35,000-foot view, philosophical. You seem to be very knowledgeable about the situation. The bill itself has 5 senators and 5 House members as sponsors. What is the need for yet another study committee when we have the expertise, I would assume, within, at least within the sponsorship, yourself and whoever else, to actually work on it yourselves and come forth with legislation next year?
So thank you for that's a fair enough question, Representative. You know, the School Boards Association, we have a continued working relationship with 100 superintendents across the state, 100 business managers across the state. Again, I haven't spoken to Senator Chanley about this bill. I don't know what specific SAU this is a derivative from. I can certainly do that offline, if you will, or in the hallway and reach out to that particular school district as well too, and perhaps our own working group, if you will, and then find somebody to sponsor legislation next year.
Thank you.
Thank you.
Further questions? Seeing none, thank you very much
Thank
for your
you.
testimony. We have one more pink card, Eric Power.
Good morning. My name's Eric Power. I'm from Brookline. I'm also the president of the School District Governance Association in support of this bill. I think this bill is important. Transportation costs have been going up. We have a lot of school districts, including the town I live in Brookline. Our K through 6 school district is SB2. And what needs to be in a default budget, what can't be, there's some language there in the law, but there is some gray areas. And so with transportation, it's one of the key things that the school district has to fulfill. And it's important that this is a complex problem. So I think it's appropriate for a study committee to look at this. You have some SAUs, about 75% of the SAUs in the state are single district SAUs. So the SAU serves one school district. You have the other 25% of SAUs are multi-district SAUs. And among those, some districts decide to contract their transportation individually, and some contract them as an SAU. And bus contracts will range anywhere from 1 year, which is very uncommon, 3 to 5 years. So if the problem comes down when you have an ongoing contract, there's not going to be a question if it's continuing what the cost will be. That would be put in the default budget because you know the contract is going on. The question happens when your contract runs out. What do you put in the default budget for the next year because you don't have a contract? And that's a good question for this committee to take a look at because it's there's a couple different aspects to it in terms of governance. So I think that it is an important committee, but I'd also want to give one caveat that transportation is one of the costs in a school district, but there can be other things such as maybe propane costs, natural gas costs, oil costs. You don't always have a contract with that. Those are usually annual based on the market. So while we're looking at transportation, if this committee gets formed, you want also, it might open up a little bit of can of worms on what you do with other things, what you put in a SB2 default budget that doesn't have a contract and what is not mandated by law. That's a gray area. So I think this committee could meet and look at those things, but you also have to be aware there might be some other areas, especially for school districts, where this might be an issue about how to clarify what's in a default budget. And I've looked at default budgets closely myself. I've talked to Representative Yokella. I found mistakes in default budgets where they weren't following the law. And I've also talked to Department of Revenue Administration, DRA, and they say the number one question they get during budget season are questions about what's in a default budget. So if this would go to any amount of helping get less calls and less demand on DRA, I think they would greatly appreciate it if we clarified this part of the law. So I think the committee would be a good thing to do and see what it comes up with, considering all these factors. And with that, I'll take any questions.
Representative Yokella.
Thank you. Thank you for taking the question. It's in my municipality, the recent concern regarding default budgets was, why is the state deciding what is and is not in the default budget at all? Why is the state telling us what is in the default budget and essentially making us pay for maybe things that we wanted to remove because we went to deliberative session and so I guess my question to you is, it seems like there's just a lack of communication or knowledge about this, and maybe actually there is no fix required for transportation. Maybe the municipality just needed to be advised that they need to put that contract on the ballot and be helped by DRA to formulate it so the known means no doesn't happen as far as spending on it. So I guess what purpose with transportation specifically is warranted in this aspect, since it seems like the municipality, if they're going to a default budget, has already spoken about they don't want the increased costs or they don't like the proposed budget, and so why are we coming up with solutions to override those voters, I guess?
Thank you for the question. I think when you get to SB2 and what goes in the default budget, it is definitely a murky area. And I think that the transportation question with school districts is probably a very good case subject area to look at some of these things, because sometimes you have a contract for it, sometimes it continues, sometimes it doesn't. And I think if you look at that, it might uncover some of the other defects we have with the default budget by looking at this case. If the study committee looks at that, I'm sure that they will see this as a case example will help maybe inform other SB2 default budget questions that certainly need to be looked at. So I think as a prime example of what happens, I think it would be very useful to have that insight and for people to hear the different issues there to help, not only solve this transportation, but maybe even the larger default budget for SB2.
Representative Cahill.
Thank you, Mr. Chair. Thank you for taking my question. So as you know, we're required in our Constitution to provide an education, and that's a financial number. Uh, well, Chair, okay. My question is, it seems that transportation is part of that requirement, right? Like to get them there. How much of that money allocated goes to transportation? Do you know?
I'm not sure if I understand the question.
Well, the money that's mandated comes from the state. Is any of that money used for transportation?
There is adequacy aid that comes from the state. So it's up to the school district where it comes from. There's a tax effort. Part of the tax effort is going to be from the state. Part of the tax effort will become from the federal government in terms of special education and other grants. So, but that defrays the tax effort, and then the rest of it is paid by local taxpayers. So that's a bigger question. You know, you heard about, you know, the mandate is being more than 2 miles away, K through 8. So if you have a co-op school district, like I have a 7 through 12 co-op school district, if that doesn't have SB2, but if somebody did have SB2, should that be in the default budget? And right now they do put it in the default budget if they have a contract. If the contract doesn't continue, I think it depends on who's asking and who's looking at what's going on in that school district. And I think that's an area that's very gray right now, that people do, you know, what the attorneys say. And so that's kind of what you have to look at.
Further questions, Representative Brown?
Thank you, Mr. Chairman, and thanks, Mr. Power. So I think I heard this at least twice in your testimony, that this bill is important because of the need to straighten out the transportation issue in the default budget. But I also think that you said that there are a number of other issues that need to be addressed with the default budget. So, and I thought you alluded to the fact that maybe the proposed committee should address those too. Did I misunderstand you?
I think that could be something that they would look at. I think, you know, transportation is largely driven by energy. So if you look at energy in terms of what does a school district use, I've come across numerous warrant articles over the past few years where people are doing conversions from propane to oil, doing solar, doing all kinds of things. And, you know, if you have a market-based fuel like heating oil or propane, you know, if the market goes up, the default budget's going to have last year's. So what are you going to do there? It's the same problem. So it seems to me these sorts of thorny problems should be handled. Maybe the transportation piece can handle that. Maybe the committee could add that as another thing to look at, you know, these kinds of issues in school districts if you need to. I think that would be some insight.
Representative Cahill?
Thank you, Mr. Chair. So, you know, I'm reading line 1 right here. Committee established. There is a committee to study the inclusion of transportation expenses in default budgets. I don't see anywhere in this bill those other things you're talking about. So I don't think that the committee being proposed here would be able to do those things. Do you agree?
I agree that the bill is now yours, and you can make amendments to it as you see fit based on circumstances. So that's what I would do if I was on the committee, because this is a challenging problem and it could do a lot of good to look at all SB2 issues.
Further questions? I have one, Mr. Power. It's the same question that I gave Mr. Christina. You obviously have a lot of experience and knowledge on this issue with the School District Governors Governing Association, and Mr. Christina with the New Hampshire School Boards Association. Along with these sponsors, don't you believe that without forming an actual committee, you could actually come forth with some legislation that would take care of the issue that you're all testifying for?
I thank you for the question. I think that could be possible. I think without a committee, though, there probably wouldn't be the priority on it that would happen in sort of an ad hoc manner. We do a lot of legislation ad hoc, but I think this is a rare circumstance where you see an agreement with a couple of different associations. So I think that having this committee look at this, it is a challenging issue. I think it's going to require some research behind it. I don't think any single party has all the answers, but it could be done. Will it happen on its own? I don't think it would.
And I have a follow-up for myself. You just mentioned exactly my point. Your two associations are generally, I would assume, not in agreement. Where you have an agreement here, I would think that would be the perfect opportunity for you all to use your expertise to get together and actually come up with some good legislation. That's a comment you can answer. It's not really a question, but we have hundreds of these study committees, and quite honestly, I've seen more action and legislation, good legislation, come out of groups getting together as ad hoc than I have as actual committees. So that would be my only comment on that. Further comments?
Thank you for the input.
Yeah. Further comments, questions? Seeing none, thank you very much for your testimony. Anybody else wishing to speak on 447? Seeing none, thank you all for coming, Senator. We'll close the hearing on that. All right, we have one more to do before lunchtime. Okay, with that, we will go ahead and open up Senate Bill 532. It's got a long name, so I'll just dispense with that for now. And we have, I believe, Grant Bossy is going to be introducing it on behalf of Senator Carson.
I would defer to Senator Carson, who just got out of her other prime bill.
Here we go. I will introduce Senator Carson.
Thank you,
You are
Mr.
up.
Chairman, and good morning, and good morning to the members of House Municipal and County Government Committee. I have, for the record, my name is Sharon Carson, and I have the pleasure of representing Senate District 14. Oh, it's on. It's on. Okay. Which is comprised of the towns of Londonderry, Hudson, and Auburn. And I have for your consideration this morning Senate Bill 532, relative to requiring all municipalities and school governing bodies to post on their official town or school website within 30 days the amount of funds received by the state, either by allocation or grant. You might ask, where does this come from? And this bill really comes from me talking with my constituents. One of the things that many of us, if not all of us, do is when we go home, we like to talk to our constituents about what we've done in Concord and what we've done to help them make their lives better. And we had a great budget last year, very bipartisan. And one of the things I like to talk about is that bipartisan budget, but also about how much money we've returned to the taxpayers for property tax relief. And of course, the response I usually get is, what relief? I didn't see my property taxes go down. And so I started thinking about, well, what's the best way to inform our constituents when we send money back to the towns? And we do it in a variety of different ways. So I met with the Municipal Association, and I talked to some of my colleagues. I talked with my town government in Londonderry. Said maybe the best thing to do is basically every time you get money from the state, put it up on the town website. Let the people know that you're receiving this money. And you could even make it even sweeter by telling them what you intend to do with it. But at least this way, the people can see that we are giving them money back, that they can use in a variety of different ways. And hopefully this will spur conversations between citizens and their town government and be a way for them to be more involved. So again, Mr. Chair, this bill is I always hate to say fairly simple, because usually when you say that, some people will see it as pretty complicated. but it's just asking them to just very simply put it up on their town website, the amount of money they're getting for us, both on the school side and from on the town side. Thank you very much, Mr. Chair.
Thank you for your testimony. I would make the comment that you're right. A lot of times when somebody says it's very simple, it turns out to be one of the most
No.
complicated. I believe this is fairly simple. Representative Gallagher, I saw your hand up.
So it on lines 5 to 6 it says, in the absence of a website, a political division shall post the information in 2 appropriate places. Could you go into a bit more detail about what is meant by appropriate places?
Okay, thank you very much for the question, Representative. This language was added because of concerns that the Municipal Association had. We have a number of very small towns here in our beautiful state, and some of them, they don't have a web page. So they will post it in 2 places that they feel are appropriate. They could have a town newspaper, they could put it as a notice in the town newspaper, or they could put a notice up at town hall. It's going to be up to them to decide which places they feel are more appropriate.
Representative Yokella.
Thank you. Thank you for taking the question. As a member of the Budget Committee, it's my understanding in my local municipality, it's my understanding that money going to the school often if I'm understanding how it works, the money actually flows directly to the municipality, and the municipality cuts the school a check. And so, if that is the case, would the school not need to post? It would just be the municipality that got the money directly from the state, if it was for like a refund or something.
I think I really didn't, thank you for the question, Representative. I really did not want to micromanage this process, other than to say, you've got to post it, to let people know that this money is coming back to you. And really, it's up to the municipalities how they're going to spend that money. But at least we've taken a step and we've said, we're giving you this money back, or you're getting this much money per pupil, or you're getting a sustainability grant for the schools. Because most people really don't know that, and sometimes that information is really buried in town reports. I don't know about you folks when you go to your town deliberative sessions, but our books are about that thick. And if you don't know exactly what you're looking for, you're not going to find it. So this way, you're taking that information and you're putting it up there in a very simple format to let people know.
Representative Brown.
Oh, geez.
Thank you, Mr. Chairman, and thanks for taking my question. So I think I heard in your testimony that you said that this information would be posted on the website indicating how much money they received from the state. And I thought you said that it also how that money was going to be used. I don't see that in the bill about how it's allocated.
Thank you for the question. I believe that I said it's going to be up to them to decide if they want to add additional information, including how the money's to be used.
Thank you.
Representative Elwood.
Thank you, Mr. Chairman. Thank you for taking my question. This says on line 5 that this notice will be posted to the website within 30 days of receipt, but it doesn't say for how long it needs to stay posted or archived, for example. Do you see it in perpetuity on the website?
I thank you for the question, Representative. Again, I did not want to micromanage the process at the town level. It should pretty much be up to them how long they want to keep it up, or if they want to archive it. But I would think that I don't want to say anything else because I'm not in town government. And I believe every district might have their own policy. And again, I really did not want to micromanage this.
Thank you.
Representative Majori.
Thank you, Mr. Chairman, and thank you, Senator, for taking a question, which I think the answer might be our discretion, but Northampton just was awarded, well, Northampton is going to be the recipient of work from from a grant given to the New Hampshire Department of Transportation to fix all the damage from the last storms that we had. That means we are not going to have to spend our money, but the grant money is not coming to the town. I imagine that might be something we're going to celebrate anyway, but you would say, I imagine the answer to this would be use your discretion about how you want to post that to the community? Okay.
Again, thank you for the question, Representative. Yes, I don't want to micromanage. Each community is different. They handle information differently. And in many instances, I don't believe a one size fits all is really good.
Representative Power.
Thank you, Mr. Chairman, and thank you, Senator, for taking my question. So I appreciate this bill, and it's an interesting and a good idea. My concern is, I know in my SAU, they bury information, and that would be contrary to what the purpose of this bill is. You literally have to be Nancy Drew. It's impossible to find any information. So I was wondering, I understand that you don't want to micromanage and one size doesn't fit all. Is there any solution? Because this is important information. Would you be open, or do you have any ideas as to how we could address that so that our constituents and the members of the public can access that important information?
Thank you, Representative, for the question. I see this as a first step. I think there needs to be my personal opinion is there needs to be a lot more communication between either a town council or whatever form of government you have and a school board and the citizens. I recently found out that oftentimes a school superintendent will apply for a grant from the federal government, and the school board members don't even know. They won't know. So again, I see this as a first step in maybe getting people to start talking to each other at the local level. And I agree that a lot of times information is deeply buried in documents, and this is just made to be very simple, very clear, very transparent. And hopefully if this does pass, people will see that this kind of information being made a lot more readily available is a great opportunity to engage citizens in local government.
Representative Priest, I saw your hand.
Thank you, Mr. Chairman, and thank you, Senator Carson. We go back a long way,
we
it's
do.
like 20 years. Thank you for being here, and thank you for sponsoring this bill. As I read it, this is very simple. You're just increasing the transparency between the state and the local governments and the people in the local governments. So they know exactly what you're doing and what programs you are adopting and bringing back to them. Is that correct?
Thank you for the question, Representative. Yes, it is. Just so you know, Representative Priest and I served for many years together when he was the executive director of the Southern New Hampshire Planning Commission, and I was one of Londonderry's representatives to that commission. But you have to start someplace, and I think this is a good place to start. We send a lot of money back to our communities, but the one thing we don't do is we really don't tell them how you're supposed to spend this money. We leave it up to them to decide. And this is just one step to say, look, this is what we're sending back to you. You folks need to have the conversation about where you think the money is best spent.
Representative Cullen.
Thank you. Just imagining this kind of implementation and how different municipalities might do this. One municipality might just put like a lottery ticker up in the corner of their thing that just has the amount received from the state, right? Where it's not even broken down by the amounts received, just the total sum. Yeah. Whereas others might list each individual check that they receive from the state. You want that to be able to be that flexible to be able to comply with this law, to be able to like post it in any way, any manner that they see fit.
Thank you, Representative. I strongly believe in local control, and it is up to the municipality to decide how they want to do this. If they start doing it and they start getting a lot of feedback from their citizens, maybe they'll make their own changes. I just don't think that we should be telling them exactly how to do this.
Representative Gallagher.
So I'm wondering, so does this apply just to allocations or grants for public school, or does it also apply to charters and education freedom accounts?
It applies to all the money that we send back to either a school, the school district, or the town. If that is included, then that's going to be reported as well.
Representative Lascelles.
Thank you, Senator Carson. Towns all across the state and all across the nation, quite frankly, recently got ARPA funds from the federal government. And it sort of put selectmen, town councils, what are we going to do with these? And how can we spend these? And I know in our particular case, one of the things that we did was we bought a fire engine that was very needed. All right. Now, if you went to the people of the country and said, how did you spend ARPA funds? I think a lot of people would really scratch their head. There was a lot of money that came from the federal government that was spent, and it was sort of left up to the local people to do that. So would you say that in the case of this particular bill, you're saying for funds that are coming from the state, particularly unanticipated funds, some funds are anticipated, but others are unanticipated.
Yep.
So those, I would hope that when we implement this, that we would make that differentiation between what is anticipated, what was budgeted for, but then what was kind of extra money. All right. And that's extra money really has the potential of lowering local property taxes. And I think that's the target. It's the money, let's say that the state has extra funds and they shoot it back to the towns, and we're really hoping that there will be some property tax relief. But if the town doesn't choose to spend it that way, then it doesn't end up being property tax relief. Does that make any sense to you?
Yes, Representative, I hear exactly what you're saying, and this is the beauty of our government. The ARPA funds came from the federal government, but were dispersed through the state. Most municipalities really didn't know, or the people, how much money their municipality was getting. If this bill had been passed, they would have known. So it can facilitate a conversation because now people can see, oh, we've got so much money coming into the state, whether it's anticipated or unanticipated. And I'm going to go out on a limb here because I'm remembering Londonderry. There was a time when we received unanticipated funds. We had to hold a special meeting to decide how to spend that money. And I want to say that there's an RSA that requires that, but I'm not an expert in municipal law, so please take that with a grain of salt. I'm going to leave that up to you folks. But the point is, people will know that the money is there, they've received it. At that point, have a conversation with your community and say, what are you going to spend this money on? because again, most people don't even know. They have no clue how much they get.
Thank you.
Thank you.
Representative Tatro.
Thank you, Mr. Chair. Thank you, Senator, for being with us today. I just have a question on the wording where it states that the requiring municipalities and school governing bodies to
I'm sorry,
post.
Representative, I'm sorry. I can't hear you because there's a lot of construction noise.
No, really?
I was going to say, be careful when you go out because you're going to walk into this huge cloud of dust outside.
A very big machine. I'll try to speak up or get in between the crashes. It looks to me as if the municipality or school governing bodies both get noticed about the money's coming through. Are the taxpayers, and they both post it, are the taxpayers going to be looking for double the money because it's the town said they got it and the school district said they got it?
Thank you for the question, Representative. I don't believe so. I think our folks that are working at the municipal level will be able to make that distinction because the money, although it's coming from the state, one's coming through the Department of Education, the other's coming from the Department of State, whether it's from transportation, HHS, or any other department. So I think they're going to be able to make that distinction.
Okay, seeing no more hands raised, Senator Carson, you are relieved. Thank you
Thank
for your
Mr.
testimony.
Chairman. See, I said I thought it was simple, but it wasn't. I got a lot of questions, and that's a good thing.
Yeah.
That's a
okay.
good thing.
Very good.
Thank you all very much for your time this afternoon.
Thank you. You have two more cards, Eric Power.
Hello, my name's Eric Power again. I'm from Brookline. I'm in support of this bill. I think it's really important from a transparency perspective for towns and school districts to say what money they're getting. I'm one of those hardy boys or whatever you say that goes and looks at these things in detail. So I know where to find it, but people say, how do you do that? And it's actually something you have to, it's a skill, but it shouldn't have to be a skill where you have to really hunt for things. We get a lot of money in the town. People aren't aware of it. I mentioned I served on our co-op school board. I actually suggested this one time to the school district at the school board, and they says, why can't we tell them we get this money? Well, people will figure it out. They can read it in the town report. And I'm like, well, we should make it a little more prominent. I mean, as legislators, you do a lot of great work here. You pass budgets. Even for yourselves, it would be great to know what's coming from Concord, because people don't generally know. And this would definitely make it more prominent. Serving on the planning board in Brookline, we've gotten some grants. We got a grant to do a hydrological study. We had another grant to do some planning for housing, workforce housing. And people look in this and they say, you guys spend a lot of money, but that was a grant we had gotten from the state, and people just aren't aware. They think we're just spending money that we don't have, but we got this money. So, I said, yeah, we got this as a grant. And so people aren't aware of that. So with ESSER funds coming into school districts, with ARPA funds coming in, it just makes a whole lot of sense to have this. And I think this is a good first step. I think that, municipalities and school districts will implement this the way they want. But I think, the consumers of it are going to say, if it doesn't meet their needs, they're probably going to say, we want you to break that down a little more, or we'd really like to say what you think you're going to use it on. But I think just from a transparency perspective, I don't think it's a big burden on school districts in towns to do this. And it might even help them to see, what money they're getting and how they're trying to do their job as the governing bodies of their towns and school districts. So I think it's a very good bill. I would recommend this passage, and I'll take any questions.
Thank you for your testimony, Representative Yokela.
Thank you. Thank you for taking the question. So in the last speaker, they're like all about local control, and we're going to be seeing this information kind of dispersed throughout a bunch of different websites, maybe posted here, posted there. If they don't have a website, it seems like that all this information is at the state, since the state is paying municipalities. So wouldn't a better place to house this information be on the state website, so that you could see all of the municipalities, and you could break it down, and we could break it down as much or as little as we wanted to, and then the information is just there all in one place, instead of having to hunt and peck and try and track down what the method or back page that five links deep on your municipal website of where the money is actually getting reported out.
That's interesting, but even at the state level, you have different organizations getting it, and I think most people, the average citizen, doesn't go to the state websites. Maybe some do, but I don't think that's common. But a lot more people tend to go to their local municipality website, their local municipality, their local school district website. So I think, and they can present it the way that makes sense locally. I think that's an interesting idea. That might be something that could be considered, but I do think, putting the information down at the local level makes a lot of sense. And if they wanted to augment it, for example, as the senator had mentioned, they could augment. We got these ARPA funds, and I know in our town, I didn't know this until I asked some questions. They're going to use ARPA funds to buy some voting machines. Wow, no one knew that. Just I found that out in passing. But they could augment that at the local level. So if the state had it, they could say they gave us the ARPA funds for $30,000, but it wouldn't be able to have the information locally that we are going to plan on using 25,000 of that for 2 voting machines, for example. So there's some pluses and minuses there, but I appreciate that concept.
Further questions? I see none. Thank you very much for your testimony, Mr. Pryor. And one last pink card. Mr. Christina is back up.
Thank you again, Chairman Turcotte. Good afternoon, I guess, at this point. Members of the committee, Barrett Christina from the New Hampshire School Boards Association. We're not taking a position on this bill. We don't have any specific objection to it, but I just wanted to highlight to the committee that the information that is sought to be posted on the school district website is already available in a multitude of places. It's listed in the annual report, the school district annual report, that is required under both RSA 198 and RSA 32. The Department of Education has a program, what is called iPlatform. Every bit of data that school districts are required to submit is available on the State Department of Education's website. Everything from state aid that's given to student dropout numbers, attendance numbers, proficiency scores, every bit of data that you could possibly want about your local school district is listed on that, which is housed and created by the Department of Education's on the Department of Education's website. The other thing that I would want to clarify as well too is state adequacy grants. The money that's distributed to schools is distributed to the school districts 4 times per year: September 1st, November 15th. September 1st. November 1st, January 1st, and April 1st. As I read the statute, you would have to update your website those 4 times a year. That's fine, I suppose, but the reality is by October 1st, districts know how much money they're getting or by November 1st, I believe it is, how much money they're getting for the course of the year. The one question that I do have, and this came up a little bit with some conversations about some of the ESSER money, some of the federal grants. The language states, the public body shall, I'm on line 4, shall post the amount of funds received by the state, either through allocation or grant. Is this intended to apply only to state grants and state money? School districts receive all sorts of federal grants, special education grants, other grants from other federal agencies that, a school district might apply for, and it's sort of pass-through money. They may apply through a special grant through the U.S. Department of Education, but that money comes into the State Department of Education and then is allocated to the local school district. So that's not state money, but it's being received by the state. So just one clarification on whether or not the bill is intended to apply to just state money or money that is federal money but pass through money that is then moves on to the district or the municipality. So in the interest of transparency, absolutely. The more information we can post on our website and make it easier for members of the public to access in an easy to read format and not buried on, some 10th page that you have to access, that's all well and good. But just wanted to point out that the information is available in a multitude of other places, and a multitude of other websites. And the one question I have about line 4. And with that, happy to answer any questions that the committee may have.
Thank you. Any questions? Representative Yokella.
Thank you. Would it be more clear if it was just essentially a page on the New Hampshire Treasurer's website? So any check essentially they've written to the municipality, then that would be essentially meet the purpose of this bill without burdening the municipality with tracking down like where did this money officially come from and all of that kind of stuff. Do you think that would be a better solution?
Yeah, thank you for the question, Representative. I hadn't contemplated that till you asked the question to the previous speaker. I think that's certainly worth consideration. There is also another bill, I forget the bill number, that was heard in House Education yesterday that would have required the school district to post all sorts of financial information and data on the school district's website. And one recommendation that was brought up by a school superintendent was link your school. I mentioned the platform that is hosted on the Department of Education's website. Maybe the district has to post their specific link. The Concord School District will post the Concord School District data through the state website on the Concord School District website. I think that would be perhaps an easier solution, perhaps in line with what you're talking about, Representative, rather than, every month we get a new grant in, or every 4 times a year we get our adequacy aid in. Somebody's got to update the website. And not that that's a huge lift, but it's another administrative task that we would be having to undergo perhaps multiple times a year.
For the questions, I have one. You hit on an area I had a question on, and that is federal funding. Does, let's say, a school district, any federal money goes through the state, not directly to the school, correct?
Correct.
Okay.
Yes.
Thank you. Further questions? Seeing none, thank you very much for
Thank you
your
very much.
testimony. I have no more. I have one pink card on the way. Ms. Heck is going to come up and speak.
Good afternoon, members of the committee, Mr. Chairman. For the record, my name is Catherine Heck, and I represent the New Hampshire Municipal Association and the 234 cities and towns in New Hampshire. And I apologize that I was unable to hear prior testimony, or if I am redundant, please feel free to stop me so I can be brief.
Could you pull that mic a little closer to your mouth, please? Thank you.
Yes, of course. So feel free to stop me if anything is being repeated that you've already heard. I don't want to waste anybody's time. I had met with the sponsor of the bill originally in the summer, who was looking for some clarity around when cities and towns and schools receive their funds versus when they are reported to the public. We did go through all the different various documents that towns would provide to their taxpayers so that they do see these funds. So the DRA MS 636, for example, contains all state aid, federal grants, any one-time payments. That report is filed with the state, but of course it is filed at a certain point in the year. We also have our annual report, as you've all seen in your own communities. That's required by law, and the funds would be reported there as well. The LBA, the Legislative Budget Assistant, will also do a report that is broken down not only in the large amount of money, the overall allocation provided to cities and towns, but they will break every grant down on their website, usually about 7 months later after the budget passes, for example, or they update it usually in May of every year, and every single community that receives funding, it will be broken down. So while we can see the funding in various places, it is not reported quickly. So when you all pass the budget and we receive funding, or perhaps you have given us a one-time payment, which we've seen quite a bit of one-time funding. I'll give you a very specific example. The highway block grant, we receive 4 payments a year from the state. It's reported in our annual report. It's also reported in our DRA report, so they can be found in both places, as well as the LBA. However, when you gave us the one-time payments, you voted in May, the end of May, to approve the budget. We had the one-time funding, and we didn't find out our allocations until just the following December. So we could kind of have estimates, but we didn't have those dollar amounts till December. So they may or may not, depending on timing, even make it into that annual report just based on when the state decides that it's going to release the funding. Meals and Rooms is another great example. We have benefited greatly from the new formula that you have all approved, and we thank you very much for that. But we do not know until we set the tax rate what the Meals and Rooms amount will be. So it's the state treasurer provides the number to the DRA and by October 1st, but cities and towns, until they call the DRA to set their tax rate, are not made aware of what that number is. The report is then put on the treasurer's website once all tax rates are set. So towns don't have this information in advance. So this was a compromise with the sponsor so that when we do become aware of these dollars, whatever they are, that we can then report them to the public on the website or in a newspaper if no website is available. So I hope that gives you a little background as to how we got here.
Thank you. From your testimony, I'm assuming the NHMA is in favor of this. You
We
didn't
are-
say from the beginning, so
We are neutral.
you're neutral
on the
it.
bill.
Okay. Thank you. Questions? Representative Hicks?
Thank you, Mr. Chairman. Thank you for taking the question. Do you think it would be,
Could you pull that mic a little
Sure.
closer to you, please? Thank
do you think it would be better for municipalities to add something into this bill that might say on line 4, bodies shall post or provide a link to the amount of funds per Representative Yokella's comments about linking to other websites?
Oh, and I apologize, I didn't hear. I think that could be a great suggestion because there are plenty of other places. DES, for example, when we get a grant, if it's a specific grant to a municipality, that will be on their website, DOT. There's so many places this information exists. And I think the sponsor's intent, from my understanding, and I don't wish to put words in anyone's mouth, is to make sure that the taxpayers and the public knew when you all vote to give us money that they were able to see it in closer to real time to when we're receiving it. I think that was the intent of the bill. So I think a link could be appropriate as well. It's whatever you see fit. Other states actually have a state website where you can put in the town and it's updated regularly. And I have examples of that. It's called the Cherry Sheet, for example, in our neighbors to the south. So you can see constantly what new aid might be coming into a community, but this is a different way that we would be handling it here in New Hampshire, a different way to solve the same issue.
Further questions, comments? Representative Yokella?
Thank you. The sheet that you were just mentioning, Cherry?
Cherry Sheet, yes.
Yeah. Is that, if you know, do you know if that is maintained by the state treasurer or on the state treasurer's website, or is it its own dedicated website? How is that administered?
I believe it's their budget office that handles it, and they compile the information coming from the different places, but I'm happy to, I have a copy, I'll give it to you. Connecticut has, several states have it, and we do maintain this. The LBA will update it every May and October, so we can go to the LBA's website and get these documents broken down by community or by school district with the aid provided to them. but it's only updated twice a year, like our annual reports are updated once a year. So I think this was looking to solve a different concern.
Further questions? Seeing none, thank you for your testimony.
Thank you.
I have no more pink cards. With that, we will close the hearing on SB 532. Okay. Our next hearing is at 1 o'clock. Sorry, everybody, that we're not going to get an hour, but 1 o'clock. Also, before everybody gets up and leaves, if you, next Tuesday, I hope everybody got the email talking about we're going to have 2 more bills that we need to have hearings on, and I'll plan on that time execing the bills that we heard today. Representative Price? I'll get, after I figure out the timing of it, I got to go talk with Jamie right now and work that out, but most likely 10 o'clock again, maybe 9:30. And that's it. We'll see you back here at 1. What's interesting is all these waters from all over the world, they all taste exactly the same. They're all filtered, they're all, you know, but okay, it is 1:15. I'm not sure where the senator is, but we do need to kind of get going here. Just so everybody's in the room, we will hear two bills next Tuesday, beginning at 9:30. We are going to start at 9:30, and then we're going to have all of the bills we did today, plus at least one of the two next week we're going to have to exec because we just found out it's an early bill. So we will be doing that. Yes, Representative Cahill. We'll give the senator another 2 or 3 minutes, and then yes, you can do that. '23rd. Just under the gun, Senator.
Representative Brown?
Okay, we'll go ahead and open up Senate Bill 491. I see the sole sponsor, Senator Bradley, is here. It is your floor, Senator Bradley. And before the senator starts, we have a blue sheet with 4 people who signed up. We only have 1 pink card, so if you intend to speak, you need to fill one out. Senator Bradley, go ahead.
Good afternoon, Representative Turcotte, members of the committee. Pleased to be here. Here on behalf of a constituent request, and he is here.
Could you do one thing
Yeah,
for
I
me? And
introduce myself?
No, pull the mic a little closer
Oh,
to you so we
sorry.
can hear you.
So, I should introduce myself first. Sorry about that. Jeb Bradley from Wolfboro here as the sponsor of Senate Bill 491, and I apologize for being a few minutes late. We weren't sure when folks were coming back, so thank you for your forbearance. This is a constituent request that came as a result of an issue in the town of Wakefield. It deals with private road agreements, and the bill is trying to make clear that municipalities may enter into agreements to maintain a private road without having to be responsible for the long-term obligation of upgrading that road. So I think, as you will hear from my constituent, there was some concern about on one of the lakes in Wakefield, road not being maintained, the impact on water quality, and the town apparently was willing to maintain it, but the status of the law, if they start maintaining it, then they are responsible for the long-term upkeep of it. So the bill continues to say that a municipality has to be responsible for getting the written consent of every owner, and it would have to be in clear language as to what they were trying to do, and the Department of Transportation would adopt rules. So hopefully a very simple bill, and thank you very much.
Representative Power, question.
Thank you, Mr. Chairman, and thank you, President Bradley, for taking my question. So I may be a little confused. I thought that I heard that you say that the purpose of this bill was with regards to maintaining the road. However, in line 4, that I see that it says that the agreement pertains to allowing the municipality to use the road.
And that was how the Senate committee amended it, and I think that was fine with the my constituent.
But it further says in the end of line 4 to 5, it does not obligate the municipality to maintain the road. So that is the point. Hopefully.
Did you have a, if you have a
Yes, follow up.
follow-up, go ahead.
So, so I do see that the agreement is with regard to the use of the road, and then it says further, lines 4 and 5, that the agreement shall not obligate the municipality to maintain the road.
That's correct.
However, is there the ability for that agreement, perhaps, if the road's being used, could there be a mutual agreement that the municipality might also maintain the road?
And that is, it just, as I understand it, it would allow more flexibility in the case that there, is some issue on a private road that the town, for whatever reason, in an agreement with the property owners, would maintain it because of maybe through traffic, maybe an impact on a water body, something like that. But it would not commit the town to a long-term obligation.
Representative Stavis, did you have a question?
Yes, and it's actually a follow-up on Representative Power's question. I understand that this is an amended version of the bill to utilize the word use the road instead of maintain the road, but how will future legislative bodies in municipalities be able to differentiate between maintenance and use? Those are two very different things. I think words here mean everything, and I wonder if you'd agree with that.
And you know what? I think I'm going to let Mr. Robbins, my constituent from Wakefield, try to answer that because he's the one that brought this to me.
Representative O'Kelley.
Thank you. Thank you for taking the question. So it seems like the way you've presented this bill to us is that somewhere in statute, essentially, if you start maintaining a road, then the municipality is on the hook forever. However, this is a new section of law, and it's not actually repealing and replacing some existing requirement. So one, I'm wondering where that requirement exists in the law, and two, does this? It's not clear that this exempts from that other section of law if that other section of law exists.
So I'm not sure I can answer the other section of law question, but just based on what the situation was in the town I represent, this was intended to fix that so that the town would be able to, on a temporary basis, help repair a private road without a long-term obligation.
Representative Brown.
Thank you, Mr. Chairman. Thank you, Senator. So I'm familiar with some things in my town of Moultonville, which they're trying to do along these same lines. So I've spoken to my selectmen about several of these issues over the last couple of years. But to me, it seems like the item that really controls this is the fact that this is a contract. So there's a limited term to this contract for use of the road and for maintenance of the road. And also that the fact is that when they enter into the contract, it would determine who is going to maintain that road and for what time period. Am I correct in that assumption?
I think you've probably done a pretty good job of explaining one potential option that this would allow without that long-term maintenance. Yes.
Okay.
Thank you.
Follow up, Mr. Chairman.
Go ahead.
So the follow-up question in regard to this is that also concerning that I want to make sure I understand is it says that the Commissioner of the Department of Transportation shall adopt rules pursuant to the RSA governing this law's requirements. So have you worked with the Department of Transportation and tried to understand what this is? Or is there any kind of guidance that, or did they testify in regard to this?
I don't recall that they testified in regard to this in this.
Okay, thanks, Senator.
Yep.
Representative Majori.
Thank you, Mr. Chairman, and thank you, Senator, for taking my question. If there's change in ownership on the property, is that left to the discretion of, or is that left to the discretion of however the agreement was written, or does that make the agreement null and void in your opinion?
So on line 4, it's pretty explicit. The municipality shall be responsible for obtaining the written consent of every owner of the road. And so I would interpret that to mean regardless of any change in ownership, if there were any kind of ongoing, commitments or issues.
Representative Elwood?
Yes, thank you, Mr. Chairman. Thank you, Senator. I have the same concern as to where this contract would be, archived. I'm wondering if it should be registered with the Registry of Deeds. Should it be an attachment, this contract, an attachment to the agreement, written agreement? I mean, I just, and I also wonder, obligating private road owners to something that we haven't seen the rules, from the DOT, what that would be about. So can you expound on that at all?
So in terms of registering it with the Registry of Deeds, I'm not sure that's necessary, but, I'm open to that discussion. And in terms of the second part of your question, as this was brought to me, it was meant to be temporary. And so, again, I think that the protection for the property owners is there, and that they would have to agree with the municipality doing whatever they would do on a short-term basis.
Follow up?
Yes, sir. I don't read temporary in here whatsoever.
I understand that, but that's how it was explained to me.
Okay, I get it. Thank you.
Representative Frecht?
Thank you, Mr. Chair. My question would be, if a town enters into an agreement with a landowners association to do work on a private road, would the town then assume the liability for any damage that they did, or would that liability still lie with the road maintenance association? Thank you.
I'm not sure that I could answer that. I mean, this is meant to be enabling for towns to be able to cooperate with private road owners if there's a situation where both sides need to take action. So long-term implications, I'm not sure I can answer because I haven't seen it.
Representative Stavis?
Thank you, Mr. Chair, and thank you for taking my question. I understand that you don't have a lot of details about the bill, but I have some hypothetical questions. I would imagine that homeowners on private roads would flock to this, would it become law, because everybody needs to have their road maintained, and it costs tens of thousands of dollars to do so. And if a New Hampshire law exists that allows municipalities to enter into such agreements, I would imagine that many homeowners on private roads would want such agreements. Where is the fairness in that to those homeowners on private roads who may not be able to convince their legislative bodies to enter into such agreements, but maybe their neighbors on another private road have managed to convince their municipalities to do so? It seems to me that there are two categories of roads in New Hampshire, those maintained by the municipality and those that aren't. And those roads don't meet, so to speak.
So again, I think this is meant to be enabling for those circumstances where there is agreement between a municipality, because it says may, doesn't say shall, it says may, and an agreement has to be signed by every owner on the road. So private road owners go before town meetings all the time, trying to get the town to take over the long-term obligations on that road and make it a town-owned road. I mean, that happens virtually at every town meeting, and whatever the legislative body is has to make a decision whether it should or shouldn't happen. This is, as I understand it, would allow some maybe more short-term option that wouldn't obligate a long-term situation to repair, use a road that needed that kind of assistance, and property owners that it would benefit both sides, the town and the property owners. That, as I understand it, doesn't exist in law today. So, you're asking a lot of questions. I'm sorry I don't have every answer for that. It is a constituent request because it was a real situation that occurred in Wakefield, and my constituent, Mr. Robbins, can probably walk you through exactly what happened and why, in the situation in the town of Wakefield, he has felt it's necessary.
Further questions for Senator? Seeing none, thank you very much. Is there anybody else that plan to testify on this? You need to fill out a pink card, sir, over there. Okay, just put your name and bring it up to me, just so we know who you are and we have a record of it. I'll tell you what, you can go testify and then fill it out before you leave. How's that? I thought you had already filled it out. Okay. So what I'm going to ask you to do is first turn on the mic, explain who you are. I'm assuming you're in favor of this, and then give us your testimony. The right button, press it down and just release it. There you go. Pull it close to you so we can hear you.
Almost like I know what I'm doing.
Pull the mic closer to you because we're not going to be able to hear
Push
you.
this closer. You're the first person who said they couldn't hear me in my life, but go ahead.
Okay.
Yes, I brought this to Senator Bradley about 1.5 years ago, and obviously last year's legislature
Could you hold on one sec. Let us know who you are, your name,
excuse me.
where you're from, and whether you're for or against the bill. Thank you.
Okay, it's Chuck or Charles Robbins from Wakefield, New Hampshire. And I'm for the bill. I'm the catalyst behind this being here today. And I spoke in front of the Senate back on February 6th committee, and they were helpful. And Senator Gray was great. He was the one who put the amendment in to add legislative bodies, the first language, so that us, the town people, would vote on it and put it into our zoning ordinance. And the purpose of it is, for years, since 1984, like all of you, we've swam in the New Hampshire lake since we were born. But since 1984, I've sent out letters in my town to for the different lakes, and I've watched what's gone on with the lakes. Back in the 80s, we were concerned mainly with sewerage, and that was a big point, and there was 13 points that the DES sent out. Don't feed the ducks because they'll have more than one litter. So there were many points. Don't use colored toilet paper, things like that. I got phone calls over that one. But over the years, the bigger problem, obviously, when we all were kids, we all went swimming in these lakes, and we probably used soap because no one had showers. Nobody had washing machines. No one was, if you had a 55-gallon drum, that might have been your septic system. So people used them as camps. So the impact over the years has been that people are spending a lot more time there. As we all know, we're getting a lot of knockdowns in new homes with new septic systems, but still the impact. But the big thing that I've learned over the years is, and
And my background is development. I've done gas stations, billboards, housing subdivisions, so I have some excavation knowledge for dirt work. But over the years, I wasn't really that sharp until probably 7, 8, 10 years ago that all this gravel that we're bringing into these private roads every year, and sometimes town roads, but mostly private. We have 50 miles of roads around Shorefront in Wakefield. So every year we bring gravel in, and I was made aware it's filled with nutrients. So these nutrients, as it disappears, it ends up in the lakes. What it's doing is, you've all heard about cyanobacteria, and that's everywhere now. And the biggest thing that we're missing is, one of these results is dissolved oxygen, the breathable air in these lakes for the aquatic life is disappearing. I'll give you 2 examples of our 6, 7, 8 lakes in Wakefield.
Could you hold on just 1 second? No, up front, up here. Chairman? Hi. Could you try to speak to the subject matter of the bill? The bill is whether or not a town is going to maintain a private road or not.
Great.
All the other stuff you're talking about really doesn't apply. We need to hear
All
why.
right, great.
Okay,
So the
thank
reason,
you.
so that's a good place for me to stop then. So all this gravel that I'm talking about, we have to find an alternative. We have to control that erosion that's going into the lakes. Now, the rules that the Supreme Court has ruled down, if you even go in and plow these private roads, you may be held responsible. So when I proposed this to the town a couple years ago, that was one of the concerns of one of my selectmen. We've had culverts blow out on these roads, and because the culverts blew out, we've had to go in and deal with it. Well, the town's been very afraid to deal with even replacing a culvert that's stopping people from getting to their homes because they don't want to take ownership of the road. So that's what this is coming from, is the fact that these roads have to be maintained, but the towns don't want them. Someday, if all the people who live in town vote to take a road over, that'll be different. But until then, most towns don't want to own these private roads. And I'm specifically talking about lakes. You people may have heard about other towns that have private roads not near lakes, and that's a big issue too, I'm sure. But in order for the town to go in and work on these lakes, not have to take the responsibility of them, I'm a real estate guy, you can make a deal. You can write out the specifics in that contract. For the year 2024, we're going to go into Lake Road, and we're going to work from this point to this point, and we're going to perform these duties. And both parties agree. The landowner, who would be the road owner, if there's multiple, you'll have to get everybody to sign off on it, and the municipality. Spelled out in here would be no responsibility to the municipality beyond what they're saying they're going to go in. And in Wakefield, just as an example why this is so important, and it's a reflection to the rest of the state, we are 70.8%, almost 71% of our total revenue comes off of these lakes. We spend very little to protect them. In 2016, I fought to get a shoreland officer in, one of the first, if not the first, in the state, because the DES is way overstretched. They have one guy taking care of multiple lakes. It's just, we don't have any enforcement. So if there's any questions, I'm sure I've talked more than I should have, but go ahead.
Representative, we'll start over there. Representative Priest, go ahead.
Thank you, Mr. Chairman, and thank you for being here. If the town goes in and makes the necessary improvements for your private road, will they then come back to you and assess you for the work that they have done?
Assess who? Assess who?
Assess the property owners that are getting the benefits from the road improvements.
I think that's a reflection of the sale price, and in Wakefield, we do every 5 years. Some towns do every year. But if anything is done to a property, if you have a better view, anything, you'll be assessed for what the assessor perceives as an improvement, I would assume.
Representative O'Kelly.
Thank you. Thank you for your testimony. Since you referenced this Supreme Court decision, are you familiar? Can you tell me what the the Supreme Court decision, the name of it was, and or the law that they were basing that
I left that package in the car. I've had it for years in my pocket. I wish I could give you the number.
I mean, you could follow up.
Well, I could follow up with you.
Yeah.
But the Supreme Court has constantly ruled that towns should stay away from any type of financial or physical involvement in working on private roads with as little as, and that one big case was about snow plowing, which we would think would be pretty innocuous. But just because they were snow plowing that road, the state said, the Supreme Court ruled, you're working on that road, you're accepting responsibility. So that's what we're trying to avoid.
Representative Elwood.
All right, so thank you, Mr. Chairman. Yes, statute does say, I think, if you plow, if the town maintains or repairs a private road within, I think it's 5 years, if they do it continually for 5 years, that they're then obligated to continue maintaining the road. How would the town be compensated for doing plowing, repair, or maintenance on the road?
Well, I think that the point is in Wakefield, we have a $20 million budget. And as I said, 14 million of it's coming from there. 90% or better of the people paying those tax bills do not live there year round. So we don't have school children from them. We don't have public services, dump, police, fire at the same rate as a citizen. So for us, we have a 685 tax rate. We're the cheapest town in the state of New Hampshire for any town with more than 4,000 population. 5,000, excuse me, 5,000. Molten Borough has 4,300 and they're cheaper. But Wakefield it's unbelievable to live there. I live on the Milton Mills town line. My house is 4,200. The same house over the line would probably be 11 or 12 grand. And that's reflective of Rochester, Dover, probably the towns over here. So the benefit to these lakes and the overall benefit to the state of New Hampshire, people are coming here for clean lakes, not cyanobacteria laden.
We'll get off
dissolved
topic
oxygen. Go
again.
ahead. Sorry, man. Go ahead.
Representative Brown.
Thank you, Mr. Chairman. And thanks for taking my question. And I am one of the representatives from Molten Borough, so
All
I
right.
know what you're talking about. So at any rate, I guess one of the things I'd want to ask you about is, this is a temporary contract, but also have you reviewed this with your selectmen, and is this something that they've said they want to do?
Well, what happened was, because I'm always in there pushing the lakes, I did a survey in 2021 on this specifically. I'm working on private roads and putting a crew together, and I got a 5-to-1 response. And you had to give me your name, address, and what you thought. It wasn't anonymous. So when you get a 5-to-1 response, I brought that into selectmen. I brought that survey in and showed them the taxpayers are willing, but one of the selectmen, smartly brought this point up. I said, I'm a real estate guy. You can make a contract with anyone. You don't need the state law, was my belief. You should be able, they still would be more comfortable if the state would back them up and say, we make a contract with someone that's usually legally binding. At least the state's not going to, and the Supreme Court's not going to tell us that we have to take the road over.
Follow up, Mr. Chairman. So the question I have then in regard to this is, what would prevent the town or the property owners in Wakefield from saying, okay, you fixed my road this year, you took care of the culverts this year, I'm real happy. Then 6 years later, 5 years later, they want to do another contract to maintain their road, basically.
I think both, like any contract and any deal that you do in life, both parties have to be willing to sign on to that.
Thank you.
Representative Cahill.
Thank you, Mr. Chair. I'm over here, sir. Thank you for taking my question. Is your town currently maintaining your road, plowing, anything like that?
No, none of we stay away from it. As I say, we have 50 miles of shorefront, so we have almost matching amount of roads, and most all of them are private. So the town has been very aware that you don't go near those roads.
Follow up, go ahead.
I was referring to your individual road, your road. Are you on a private road, sir?
My home where I live, I'm on a regular town road. I just 4 years ago bought on a camp road, and I had land on a camp road for years before that, but I'm on a camp road where the people really take care of the road. They do a monster job. They do as well as any municipality could, but they bring in gravel, they grade it, the gravel goes in the lake, and therefore New Hampshire's losing this valuable tax revenue.
Further questions? Representative Majori?
Thank you, Mr. Chairman. This question may be getting too far into the weeds. I'm not really sure, but if the private road has been recognized by the planning board, then the municipality can make it, the governing body can make a decision about whether or not they're going to accept that as a dedicated road. In this instance, what I'm concerned about is if the road has not been recognized by the planning board, in order for this road to be recognized by the municipality, it needs legislative body approval, a warrant article. So I'm wondering if we have gotten if I'm getting so far into the weeds where you have contemplated whether or not that contract would have to go before the legislative body as a warrant article for approval.
Well, I think that what Senator Gray added in his addendum, the first line, legislative bodies of the municipality may enter into agreements. I think that was a sharp thing that he gave me on the Senate committee meeting. But, private roads are a big thing. But for a town like Wakefield, when you're talking almost 71% of its income, if a company comes to your town or your state and says, I'm going to employ 1,000 or 100,000 for the state, most communities, they give them 5 years of free taxes. They bend over backwards when you bring that type of revenue in. That's what these lakes are. They're a huge revenue driver for the state. Thank you, sir.
All right, further question, Representative Gilman.
Thank you, Mr. Chair, and thank you for taking my question. I'm right here.
Oh, hi.
When I first read this and I saw the word use, my impression, and that it's just what came to my mind, was municipal trucks or vehicles passing through on a privately owned road. Not anything about constructing a road or maintaining a road, just using it like you use any street. Is that, is use maybe the wrong word?
Well, I think that the key here is no work is going to be done until there's a written contract between the owner of the road and the municipality. So, like you said, we can go in and look at different parts here, but this is just giving the town the ability to enter into a contract with a landowner, which they could do now, but my selectman who brought it up wanted the backing of the state to say, just because we're in there working on the road and we have a valid contract with the road owner, we do not have to accept this, as the Supreme Court has ruled, even with plowing and, as Representative over there mentioned earlier, the repetitive helping of people on the road may end up having you own the road. Specifically, you would not be entering into anything like that with a written contract.
Representative Elwood.
Thank you, Mr. Chairman. Just real quick, sir.
I'm listening. Right. Oh.
Okay. My question is, did a land use attorney weigh in on this?
Did who?
A land use attorney. Did you have a land use attorney look at this and give you advice?
Well, I have a land use attorney that I've had for years. I've done this 45, 48 years. I've lived, eat, and breathed development. So I respect attorneys who've done municipal law very much, and I read the municipal findings that come, but I do these type of contracts my whole life, so I'm very versed in how I picture this would happen.
Thank you.
Further questions? Seeing none, thank you very much for your testimony.
Thanks for your patience, guys. I really appreciate it.
Okay, I don't have any more pink cards on this bill, so with that, we'll close the hearing on SB 491. We will give the clerk just a minute or two, and we will move on to our final bill of the day. Okay, Mr. Clerk, you set? All right, very good. We'll go ahead and open up the hearing now on Senate Bill. Senate Bill 383 relative to local tax caps, and Senator Murphy is prime sponsor. You are up.
Thank you, Mr. Chairman, members of the committee. It's a pleasure to be back in front of my friends in the House. This bill, Keith Murphy representing the towns of Raymond, Candia, Hooksett, Goffstown, and Manchester's First Ward. This bill is enabling legislation and allowing another method of calculating a tax cap for communities that choose to adopt it. It does add another method for school districts to implement a tax cap. It essentially allows the same methods for towns that are currently allowed for cities. And the committee amendment that we adopted over in the Senate addressed some issues that were brought to our attention during the hearing by the Municipal Association. I have with me, in the interest of efficiency, Mr. Chairman, Representative McGuire. He is a co-sponsor, and I think is very prepared to speak on the bill as well.
Thank you. So, yeah, Representative Dan McGuire, I represent the town of Epsom. So what this bill does is it modifies RSA 32:5, which is an existing form of tax cap in our law for towns, but it's not used very much because it's really poorly written. So this is a bill to make it more practical. As you're probably aware, many cities like Manchester, Nashua, Franklin have tax caps of various sorts as part of their charters. And RSA 32:5 allows towns to have similar sort of tax caps. The problem is the way it's written, those tax caps don't really work very well because the language in 32:5 says you can have one of two kinds of tax caps. You can have it such that the amount for next year is a fixed dollar amount more than this year, right? So if your budget is $1 million this year and your tax cap says $50,000, then next year your budget could be $1,050,000, right? Or the RSA allows you to have a fixed percentage, right? Like your budget can go up by 2% per year, something like that. The problem is, reality is not fixed numbers or fixed percentages, right? Reality with inflation is, well, this year it's very high, next year it's not so high, and so on. Plus the fact that districts or, the population of those districts it changes per year also, right? So some towns are growing their population very rapidly. Presumably their services would have to change more quickly than other places where the population isn't changing very rapidly. And so
what this bill does is it allows towns to have a tax cap similar to what cities now do, which is the cap can move year to year based on population change, times, and inflation factor. Okay, so that's a practical tax cap, not like the ones in here. And the bill allows these caps to be placed by school districts and or by towns, right? So on the town part of the budget or on the school district part. And there's details, but basically the adoption of such a cap and or the deletion of such a cap would be done by a 60% vote, 3/5, or overriding such a cap would be a 3/5 vote. So you need a supermajority to put it in place. You need a supermajority to take it away, supermajority to change it. But once it's in place, towns or school districts would have to follow these caps. And Representative Power asked me to mention we have, she and I have a small amendment that has to do with the timing of school district budgeting, right? So the way the school district budgeting, you know, what happens this year and next year and so on, in the bill doesn't quite match what they actually do. And so this amendment fixes that, I think. And we're happy to answer questions.
Questions, Representative Lascelles.
Yes, thank you for bringing this, and this has been needed for quite a while. You know, fixed amounts and percentages when inflation goes like this. I mean, we've seen the impact of that in the recent times with all the impacts of inflation and so forth. My question is, some towns don't have tax caps, they have spending caps. Now, does this bill impact spending caps in the same way that you talk about tax caps?
I can answer, yeah. So it's sort of a technical thing, but the way this is written is that on towns, it's a tax cap. So it's the actual tax amount for the municipality. On school districts, it's a spending cap. It's the amount they're spending because they have revenue. So towns almost have much more sort of known revenue, right? Whereas school districts, some years they get a grant, some years they don't, and all this sort of thing. So on school districts, it's a spending cap. On towns, it's a tax cap.
Representative Yokela, go ahead.
Thank you. Thank you for taking the question. You said that there is, or at least you indicated that there was very few, but you didn't specifically say that no municipality currently has this setup. And so my question to you is, if municipalities already have this setup, would you be essentially barring them from how they have it currently? And if this changes, kind of like when we change, the law regarding exemptions, they have to re-adopt it, which may or may not be easy. I'm wondering about the people that are currently under a tax cap. Will they have to re-adopt, and will they have to adopt this new structure, or are they able to be grandfathered in? If they like their structure, can they keep it?
Yes, thank you for the question, Representative. And the answer is yes. This does not affect existing. There's a handful. I think there's 3 maybe or 4. I have the list somewhere. Yeah, 10. Yeah, whatever. There's a small number. But the biggest one is dairy, in fact. But if you look on page 2, line 1, so we're just adding the word multiplication factor. So the tax cap can be a fixed amount, a fixed percentage, or a multiplication factor, right? So this is a new thing that they can adopt if they want to. But presumably the way they would change if they already had a fixed dollar amount and wanted a multiplication factor, they would have a 3/5 vote to, make a change like that. Yeah.
Representative Power.
Thank you, Mr. Chairman. I have 2 points of clarification. So the first would be that I see 3 sections in this bill. The first section pertains to a local tax cap. And I just would like to clarify that it does pertain to both towns as well as school districts. And I know that to be true because my Brookline School District has a local tax cap. And with regards to Section 2, that's a school district, but the first one's a tax effort cap. With regards to Section 2, the school district budget cap is a spending cap, and that would be new legislation that doesn't already exist. And the third point of clarification is that the bill, when drafted, was wisely put in Section 3, which pertains to applicability. And it says that with regards to the local tax caps previously in place, it does not require local readoption. And it would not pertain to Section 2 of school district budget caps because that is not in our statute.
We agree.
Do you have a response to that question?
No,
I'm
no,
kidding.
I
I'm
think
joking.
That's all correct.
It wasn't a question.
We agree.
Further questions? Representative LaSalle, your mic's still on. You have a question? Nope. Representative Majority.
Thank you, Mr. Chairman, and thank you for taking my question. I'm just curious about the calculator. If that is a new calculator that you created, or if it has some proven effects somewhere. Just curious about the origins of the calculator.
Are you asking about
in 1BA? Just
1BA?
Yeah.
So I'm sort of looking at page 2, line 19. For
sorry. Yeah, I
example.
should. So page. I guess that would be page 2, lines 13 through 17. So the way you come up with that calculation, is that based on some best practice, or is that and please forgive the word, a new invention? I don't mean invention in a derogatory way.
No, I think this is very similar to what cities do.
Okay.
Okay. And there are some details here, like, for example, on line 20, where we had the municipal cost index. So this language is fairly flexible. It allows a school district or a municipality to choose the inflation index that they want. It doesn't have to be CPI. It could be this one also listed here, municipal cost index. That's one the Municipal Association asked us to add because there are a few different inflation indices, and some may be more appropriate to municipal expenses and costs, and others to, different kinds of costs. So the organization that makes the warrant article to adopt it would make a decision. We want the such and such, the CPI or the MCI or whichever index they want. Yeah.
Representative Stavis.
Thank you, Mr. Chair, and thank you for taking my question, which I will desperately try to articulate in a way that makes sense. I'm looking at page 1, section 4, under subsection 1B, which pertains to population figures. And it's lines 28, 29, and 30. Population shall mean the population figures calculated by the Department of Business and Economic Affairs, Office of Planning and Development, pursuant to RSA 78, A25, Roman numeral 3. And as I read 78, A25, Roman numeral 3, I see some potential pitfalls that I have questions about, and they have to do with the dates by which this information is gathered. And the opportunities for municipalities to appeal the numbers they get from planning if they disagree with those numbers. Now, in the middle of all of this estimating and reporting on the preceding year's population, which is what planning reports on, how does that mesh with the need to set up an annual budget in a municipality? Are there potential timing problems there that need to be addressed?
Right. Thank you for the question, Representative. I guess I would say that you have to pick a date, right? And it's going to be, this is going to be a date that works annually, right? So if you're off by 1 year, in some sense, I don't see that as a huge tragedy. But we asked the drafters to just give us where is in law the existing sort of standard place where populations are referenced, right? And that's this spot. So I guess I don't have a better answer for you, but.
I would just also, if I may, chime in that page 2, line B, it refers that multiplication factor, and towns can adjust for that with the multiplication factor. A town growing or shrinking, if you really believe that 1 year is making a huge difference, they can adjust for that in the multiplication factor.
I'm sorry, I didn't hear that last part.
If a town is shrinking at 1% a year or 2% a year or 3% a year, shrinking or growing, they can adjust the multiplication factor when they adopt the tax cap. They can take that into account at the time.
Thank you.
Further questions, comments? I have two very easy ones, hopefully. In your formula, you have the inflation, 1 plus the inflation factor. Why is the 1 there? What's the purpose of that?
Yeah, so let's say the cap is $1 million and inflation is 2%, right? You want 1.02 times the $1 million is your new limit, right? Your new limit is $1,020,000, right? If you see what I mean. So the 1 is the existing plus the difference, right? And the inflation is the difference.
I think I was misreading it. I thought what you were getting at is it could be inflation flat factor plus an additional 1%.
No.
I got you. Never mind. All right. Second question. On line 19, page 2, you kind of touched on it. You can use one of 2 inflation indexes.
It's actually more than 2. So the first thing where it says...
Well, hold on.
I'm sorry.
But what got me is the word either. Why? And I know you mentioned the NHMA suggested one of the 2. But why either? Why are you getting away from consistency in that regard?
Thank you for the question, but this is flexibility for towns to make a choice, right? So I believe that the U.S. Bureau of Labor Statistics has multiple inflation indices, right? They have CPI dash something or other, urban and rural and different things, right? So the people that adopt this can choose one of those or this other one, the municipal cost index, et cetera, right? So they're all relatively similar, but as I understand it, the municipal cost index includes, the CPI is more or less an index based on salaries and labor and that kind of thing, mostly. And that's reasonable because most government expenses are for salaries. But the municipal cost index includes some construction factors, right? So it if you need to build, every once in a while you build a new school or a new building, that's, and roads are obviously construction. So they may argue that that's a better index. They're not that different. Right?
So basically, I guess my basic question is why the choice, but you're agnostic to which one they pick. That's basically.
Absolutely.
Okay,
Yeah.
very
Yeah.
good.
It's the people doing it are going to have to make their own arguments for it, right? And so let them
Okay.
pick what they want.
Very good. Representative Power?
Thank you, Mr. Chairman, and thank you for taking my question. On page 3, Roman numeral section 4, is it true that these fine details will be specified in the question that will appear on the warrant as to what the school district budget cap is going to look like, regarding like the picking and choosing of what the formula is going to be? It will be all specified and laid out right there in the warrant article.
Yes. Yes.
Further questions? Representative Freese.
Thank you so much, and thank you for both of you for being here. On this tax cap, I'm just curious, was there a municipality or town that came to you and was inquisitive about doing this? Was there a problem somewhere in the state that you're seeking to address? Or did you just think that this would be a good way to address this flaw in the current statutes?
Speaking for myself, I did hear from a constituent who was concerned that his town, and I won't give you the name of the town because I don't want to get this person, cause him any issues, but he was frustrated that his town was not allowing him to adopt a school spending cap in the manner that they could adopt a municipal tax cap. And I'll leave Representative McGuire answer his question. So.
Yeah, I mean, my own constituents are very strongly needing and asking for something like this because, I mean, our property tax bill, our school, our town is great. I mean, they're flat funded this particular year, but my school is spending 10% more. I mean, it's just amazing. And so my overall property tax is going to be going up 8% this year, right? So that's people are very, very in favor of this kind of thing.
Further questions? Seeing none, thank you, gentlemen, for your testimony.
I apologize, I can't stay my committee's meeting for over there.
Okay, next pink card I have, Mr. Christina. Frequent flyer today with us.
Thank you again, Chairman Turcotte. Good afternoon, members of the committee. Barrett Christina from the New Hampshire School Boards Association. We're opposed to the bill. Just to be clear, we're not opposed to tax caps. We believe that should be left into the hands of local voters. The concerns that NHSBA has with the bill is that under current law, a school district can adopt either a tax cap or a spending cap. The law allows them to select, the voters to select either a fixed dollar amount or a fixed percentage. As I'm reading the bill, if a school district does not currently have a tax cap, but wanted to implement one, they would be tied to this particular formula. NHSBA believes that the voters should be able to choose what number or what percentage that they necessarily want, rather than being tied down to a particular statutory formula. Second, in my understanding, my research, I could be wrong on this, but I believe there's only 3 school districts, and not counting the cities, I should say, only 3 school districts, non-cities, that have adopted local tax caps. So I understand that the representative and the senator said they've heard this from constituents, but this room isn't filled with people clamoring for a new method or a new version of a particular tax cap. So, we questioned I believe the representative over here asked what was sort of the impetus for this. And I understand that it's often a constituent that asks for the bill to be put in, but there doesn't seem to be a statewide desire to change what voters have been able to do for a number of years. The other aspects, concerns that we have, I believe it's on page, I apologize. I believe it's on page 2, line 32 and 33, about the bonding issues. And if you have a bond, that only the first year payment on the bond is going to be calculated in the tax cap. Your first year bond payment is often lower than some of the remaining years of the bond. Your first year bond payments are often used for engineering surveys and architecture fees, and not sort of the people on the ground like we've been hearing all day across the street digging with heavy machinery. That's NHSBA's experience anyway. So those are just the 2 or 3 primary concerns that NHSBA has. We believe that this is sort of limiting voter choice from the voters being allowed to adopt either a flat number or a fixed percentage to being tied into one particular formula. And we think that the voters should have some flexibility with how they want to do that within their own local tax cap. And I'm happy to answer any questions.
Representative Cahill.
Thank you, Mr. Chair. Thank you for taking my question. Do you think it's fair to say that the taxpayers that are maybe struggling with a lot of bills right now, inflation, high taxes, they're not filling this room right now because possibly they're at work and they elected us to be their voice?
Fair enough, Representative. Absolutely. Thank you.
Further questions? Seeing none, thank you very
Thank
much
you.
for your testimony again. Ms. Heck, you're up.
Good afternoon again, Chairman Turcotte, members of the committee. For the record, my name is Catherine Heck, and I represent the New Hampshire Municipal Association. And while I believe the sponsors of the bill who introduced the bill and did a great job covering it, really summed up some of the work we did together in the Senate on this local option, I did want to just make sure I was here to answer any questions and to just clarify a few points that I heard. One of the first questions I heard, well, first, let me also say that we are really only concerned at NHMA with the section of the bill that goes up until page 2, line 10, because the rest really applies to a school district, and that is just not the area that we get into. But we had sat with the sponsors when we saw this bill to make sure that not only was some language on a bill that we had worked on in this body around tax caps was included, in the first section of the bill that was seen in this committee, but making sure that there was some definitions put in and some understanding of different indices and how they work. So for example, we wanted to ensure that, well, CPI is an excellent indicator for perhaps a school district because it's often used for cost of living adjustments and COLAs. It may not be as accurate of a measure as the municipal cost index, which estimates municipal and county, American City and County Magazine rather has been doing this for 60 years, and they use a weighted indices using CPI, construction index, and industrial commodity index, because we build roads, we build bridges, there's buildings, and the consumer price index. So they merge all of those together and have different weights using data that shows that our typical budgets have less salaries and benefits attached than, say, a school district, where we normally see a higher percentage of the district budget being attributed to salary and benefits. So that was a suggestion that we appreciated that the sponsors and the committee included in the bill. Another point that was brought up, which is a great question, we also struggle with when and where to get population figures from. So we did work with the sponsors on this to ensure that they were using RSA 78A, which is the same measure, because we needed some standardized method that every city and town, or every town rather, this doesn't apply to cities, could use in the event that they choose locally to adopt this option via the voter. And this is used for our meals and rooms population numbers, our highway block grant numbers, and other formula grants. This is the same statute that's already being used and applied to other types of grants we're receiving. So again, we just wanted the law to be very clear, should it be adopted, that it could be enacted. I don't think I have any more comments other than to say that all of our concerns and technical issues, unless we've missed any, were addressed in the Senate through amendments.
Questions? Representative O'Callaghan?
Did you say that you were speaking in favor, opposed, or neutral?
We are neutral on the bill. It is a local option piece of legislation. Oh, and I should also add, I heard about cities and tax caps. Cities in their charters have got to place in a tax cap provision as part of their charter process, which is adopted by their legislative bodies. And several of our cities do use an inflation index or an inflationary measure as part of their tax cap. So I think this might have been some of the reason we're considering this option here. It's being used in several of the city charters.
Representative Cahill?
Yes, I had a question about that. So you're stating that the cities in their charter have a tax cap. Are they allowed to be a city without a tax cap?
I believe, we can ask Nate, but my understanding is that the charter has to have some type of provision contained within it for their budgeting purposes, because they have elected officials, they have representative legislative bodies. They do not have a town meeting the way our communities do, because they would not have a way to override. They don't have an overriding tax cap the way our local towns can actually override the tax cap, and this legislation does not preclude that from happening either. That stays the same as current law.
I see no other hands. You're free to go, Ms. Heck.
Thank you.
Okay, last pink card I have is Eric Power.
Good afternoon, committee members. Eric Power from Brookline, President of the School District Governors Association, speaking in favor of this bill. I sent something out to the committee this morning. You may or haven't in your box, but I want to just kind of highlight a few of the points about the positive aspects of this bill and answer any questions that have come up. Section 1 talks about the local tax cap. It's the existing RSA 32.5-B. It's really a tax effort cap for people that aren't aware. So what you're limiting is the tax effort from year to year. And currently, the only option is to do that by a fixed percentage or a fixed dollar amount. So a tax effort is really your total budget minus your estimated revenues. So that's what's available today. And I have experience with tax caps. In Brookline in 2016, for our Brookline School District, we adopted an 8% tax cap on our school district. We had originally proposed it at the 4% level, but there was concern about potential inflation. Voters liked the idea of a tax cap, but they felt that inflation sometime might go higher, and unfortunately that came true. We did adjust that at the deliberative session under SB2, and it passed by the supermajority vote of 60%, needed more than 60%. So this has got to be very much of an agreement for a town to do this. It's not just a simple majority. So what this bill does is it gives you other options. It doesn't take that one away. Those are still available if you want the fixed percentage or the fixed dollar amount. This just gives one that makes a lot more sense in terms of risk, in terms of you can go with the inflation factor that you choose for your town. MCI is a great one. The ECI, Employment Cost Index, is another popular one. CPI-U. You can choose that instead of a fixed percentage. And the other thing that happens with the local tax cap is that if you get more revenues, you can increase your budget. So because it's limiting tax effort, but if you get more revenue, you can raise your spending. It's because the net would be the same under the tax cap. The one thing that's not the greatest piece about the tax cap is you adopt it with a supermajority, but it can be overridden by a simple majority at the town meeting or school district meeting. But that's the way it is right now. We're not trying to change that. So the second part of the bill in section 2 talks about school district budget cap, and that's a spending cap. So that actually looks at how much you're spending regardless of income. Again, that one has to be adopted by a 60% supermajority, and that is done by selecting a cost per student. Whatever cost per student what the legislative body wants,
they pick a cost per student and then they multiply by the number of students, which we use the Department of Education average daily membership in residence, ADMR, and then also an inflation factor, just like you could choose in the local tax cap. Again, it puts a limit on the total budget and spending. So if you get more revenues, you don't get to increase the budget. That some people like that, some people don't like that. But what that would do is if you got higher revenues, it would actually go back to the taxpayers as tax relief. That's what's built in there. It limits the spending. You have the spending. If you get more revenues, then it goes down and it reduces the tax effort, which reduces taxes. Some people like it, some people don't. In general, higher revenues, so higher revenues don't raise the budget cap. Higher inflation will raise it because that's a factor there. And if you have more students, it goes up. But if you have less students, that's a factor that makes it go down. So again, with this school district budget cap, it was authored to be overridden with a 3/5 supermajority. So you have to stay within the cap unless your legislative body at your town meeting or your deliberative session decides to go above the cap with a supermajority. And there is a trend in New Hampshire right now, if you look across the state, that there's school spending. The motivation for this, there's school spending is going up, but the populations are going down and the cost per student is rising. So there's clearly a need for some taxpayers and some school districts to want this. I sent to you a graph. I served on what they call the BudCom study committee in Brookline. I was the chairman of it in 2020. And what we did is we were looking at the impacts of a budget committee. But one of the factors we did was we looked at what was happening with school districts, peer school districts, and peer towns. And with towns, we were looking at how much has the spending gone up compared to inflation and the growth in population. And for school districts, we were looking at what's happening with inflation and the number of students. And for the school districts, we had 27 peer school districts. Over 70% were exceeding what you would expect for a budget going up based on inflation and student enrollment, which only 30% were staying underneath that. So there's clearly a need there. I also have a graph in there showing an example of a budget cap, school district budget cap, and a local tax cap adopted with CPIU, what it would look like. And really, it's not drastic and it's not crazy, but it causes small changes to happen over time so you don't get runaway budgets as we're seeing today. In the packet I emailed you this morning, there's also a couple of examples showing how the school district budget cap works based on changing enrollments and inflation factors, whether you have a fixed number or you're using an inflation factor, so you can see how it works. It's all part of the packet I sent you, and I can answer questions if you have any other detailed questions on that. But I think it makes a lot of sense to have a local tax cap. It'll be much more popular than what we have today. Today, I think there's 7 towns and 3 school districts that have adopted a local tax cap, primarily because you can only pick the fixed percentage or you can pick the fixed dollar amount. So this actually gives something that more voters would come on board with because they would realize they'll be protected from inflation. If we get inflation, the tax cap will go up with it. And that makes a lot more sense, so it would be a lot more popular. So I would recommend ought to pass with amendment on this bill. I think it's a great tool. It is enabling legislation. It has to be adopted by a 60% supermajority, so no one's going to be forced to use it, but it is a tool that's available to towns and school districts. Thank you very much.
Thank you. Questions, Representative Davis?
Just wondering, in all of your calculations of school expenditures and enrollment profiles and the like, how do the education freedom accounts factor into that?
They're independent.
Is there an estimate of what people are paying for those?
That's not part of local school district spending. So it doesn't impact tax caps.
Further questions? I see none. Thank you very much for your testimony. That was the last pink card I had on SB 383. I see nobody else jumping up to come speak. So with that, we will close the public hearing on SB 383. All right. That's it for today. Again, next Tuesday, 9:30, we will hear 2 bills in the morning and then start execing some of these bills here. One of them, we were informed today that it's an early bill, which means SB 385, which we haven't heard yet, we will hear next Tuesday. We have to get it out on Tuesday. So be prepared to possibly a long day or be prepared for that one. Other than that, enjoy your waters of the world.